Division bench item 1 with 2 for delivery of order.
Before we deliver the orders, today being the last day, I hope this year was good for everyone. Give you the best wishes for the next year. And insofar as these two appeals are concerned, insofar as the appellant in criminal appeal number 158 of 2017, Raju Satnami, is concerned, we affirm his conviction and sentence. Insofar as the appellant in 150 of 2017 is concerned, the sentence insofar as them are concerned, they are to pay the fine for the offense. And so both the appeals are therefore disposed of. There is some alteration, some corrections last moment. So, which about the corrections?
Wait, item number 11, my lord. I am led by senior counsel Mr. P.K. Goswami, sir. My lord, he's having some health problem because some cataract issue. He's going to be operating. Now, can it be in the last week of January, my lord? Item number 11, my lord.
Okay. But this had been adjourned many times.
It has been adjourned many times, my lord. But today, my lord, inevitable, my lord, because he's not well. Your lordship,
Midway learned counsel for the appellant, the matter stands adjourned today. When do you want?
my lord, fixed date in the last week of January, my lord. Fixed date, my lord. 38, my lord. 38 January, my lord.
We'll make it 29th.
My lord.
30, I'm reserving.
My lord.
30.
Oh, like,
sorry, 29. 120. Both sides are represented.
obliged. Keep you obliged.
I beg to mention TRPC number 72/23, listing after vacation.
After vacation, give it to the court master.
Okay, much obliged.
May it please your lordship. My lord, I beg to mention item number 36, my lord. So up to date case date was called for, my lord.
Up to date, it is not up to last entry is 898. So it need to be up to date.
No, just a moment. Item number
36.
36. When was it moved first? When was this moved first?
Last entry, lordship.
No. What was the date when the matter was moved first?
Lordship 21/7.
21/7.
21/7. So 5 months. We can't wait. If they are not upgrading, we'll take an adverse inference.
Lordship, then today.
No, you see, we can't play with the court. The police can't play with the court.
Lordship,
When
Lordship
you
today only.
issue
then.
the, what you call for the case diary, they come after 5 months saying that we have not updated. That is
My lord.
unfair.
Then we'll take up Lordship.
My lord, after getting interim, the petitioner went to the,
No, that we don't know. We'll take up the matter.
Take up
When
it.
it comes, we'll say. But
Lord-
after
Lord-
5 months, we are not sending
Lord-
back the case diary.
Lordship.
Wait, please, Your Lordship. Lordship, this is a prayer for listing of an RFA 61 of 2013.
You make the mention when after vacation, because today you see we are not taking up any matters.
Lordship, settlement is reached between the parties, so it may be
Still
listed
make it after
after
vacation.
much of it.
Because no point having mention made now for the vacation, after the vacation.
Yeah, please, Lordship, I'm praying for listing of this MSc appeal matter after vacation.
Make the prayer after vacation.
May I please, Your Lordship? Lordship, I beg to mention item number 29, Your Lordship. This matter may be kindly, may please, Lordship, withdraw this matter, Lordship. Because on last occasion, Your Lordship approved this, I have filed wrong court, Lordship. Past earlier order, Your Lordship.
You want to withdraw it?
Yes, Lord.
Permit you.
Face.
Uh, Upon instructions, Mr. P. Sharma, counsel for the petitioner seeks to withdraw this petition. Prayer is allowed. Matters being dismissed on withdraw.
And Lordship, certified copy and Okalatnama may be kindly withdrawn, Lordship.
This is same.
Yes,
LAFT.
Lordship, this is same, Lordship.
Okay. It- Okay.
Obliged, Lordship.
My pleasure, Your Lordship. Lordship, I beg to mention item number 18. Kindly matter may be come up. Yes, Lordship. Kindly matter may be come up after vacation, Lordship.
The prayer made by London counsel for the applicant just after seeing vacation, winter vacation. 18. Okay. Okay.
Slow ruling. Slow ruling.
Should I had a prayer for listing? The reason I'm making a mention is I'll be led by an counsel from Delhi. Your Lordship. Can it be taken up?
We make a mention after this because there's some logistic problems. The system will be down in this vacation. There is some upgradation going on. That's why. Make it on the reopening day. Although I allowed first two, which I forgot at that time that there is a system. Some technical problems will be. No, not technical problem. It will be in fact upgradation. So it has to be shut down. Yes.
Lordship, I beg to mention item number 6, Lordship.
6.
Yes, sir. Lordship, the matter may be listed on 9th of February, Lordship.
9th of February.
Lordship, a similar matter has been listed on 9th of February, Lordship. It is MSc appeal 458 of 2023.
Okay. All the claim made by London counsel for the petitioner list on 9/2/2024. Okay.
Lordship, both the matter may be taken.
I am not tagging it. You said we will take it. On that day, you make adjustments. Order है बना है तो this items 25 and 26. In fact, it has been wrongly listed for deliver orders. It's not yet prepared. But what you call, since it was very too old, I've been keeping it. Somehow it escaped to pass an order. The second thing is that he knows that one of the one of the applications under similar ground that has been stayed by the Supreme Court of India. So in fact, while I take up my pen, the difficulty is that on the same facts and circumstances, the Supreme Court has stayed one of the orders of this court. So in fact, this is a case I did not.
So that judgment stirs into lordship.
You see, there are 5 applications, all 7 Rule 11, all similarly, similar argument. Same election. So the difficulty is that whenever I take the pen, that stay order comes in my face, but I'll have to deliver. Today I couldn't prepare it. All sides are duly represented. In fact, I'll fix it on please tell a date which is convenient. I'll need some what you call refreshment of the hearing. It has been too long. When it will be convenient, please check up the dates. You both agree, Mr. Barwa? Please,
They also, I think.
please consult him and then fix a date.
I think Milo will inform Milo.
Hmm?
Will inform.
Okay, okay.
Because he's, I have to consult the council, senior.
But I'm extremely sorry. I have withheld this matter for long.
Our job was easy.
Hmm?
Our job is easy.
No,
Because
no.
We make the argument.
No, it's not that, it's default on my part. This something which I have defaulted, I can't shift it on you. Outside the representative. As the matter was heard long back, the court is of the considered opinion that refreshing fresh hearing to refresh the memory of the court would be very necessary in the matter. Next para, as agreed to by both sides, list the matter for further hearing on. Just consult and give the dates. But I express my regret for the default.
Mr. Right.
দুইটা আইটেম সেম ডে দিব
সিহঁতে কৈ দিব যেনেকে কয় তেনেকে দিব
না সিহঁতে দিব সিহঁতে যদি কয় দুইটা একেই ডে For motion item 1.
Wife is before your lordship, my lord, for sitting.
What is the ground?
Ground, your lordship, and the 3 phase,
Just tell me.
there are 2 cases, my lord, pending Hussain, instituted by me.
And this case is filed where?
Nagav.
Nagaon. A transfer petition. Matrimonial dispute. Mr. A.I. Uddin, counsel for the petitioner. Notice steps within. But today you'll have to take course of the day steps in course of the day. The next date of listing, the further proceedings of page 1, so and so shall remain stayed. Subject to condition that the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court. The date, you'll get the date from the court master after some time. Item 1, 2.
My lord, this is.
Why King has to come to court?
My lord, because my written statement has been denied, which was filed long back on 8/5/2019.
Show me the order.
My lord, it is at page number 46 to 48, my lord.
46 to 48.
48, yes. is the order dated 30/9/2023. May I read, my lord?
No, where is the, you just show us where you, when did you file that written statement?
Written statement, my lord. Kindly see paragraph number 3 at page number 47. The present was filed by the plaintiff Shri Babulal Saravgi on 29/9/2018, seeking a judgment of T9 and recovery of area rent and electricity charges. Road Kings Private Limited, represented by its director Shri Anil Agarwal, was arraigned as the principal defendant. On 5/10/2018, the plaint was admitted for hearing and the summons were issued to the defendant. On receipt of suit summons, the defendant company entered appearance, and on 8/5/2019, Shri Anil Agarwal filed written statement
Okay.
claiming himself to be.
Yes, Mr. Sharma. I have to issue a notice and stay this. If a written statement is filed in 2019, 21 the petition taken up for rejection and then it is rejected in 23. So the purpose of written statement is already. Sir,
Related bit is for admission. In the meantime, next date of the case is fixed on 13/3/24. Next date of the case is fixed on 13 March 24.
13 March.
Let it come out for admission in February after vacation. So there is no need of any stay also.
Okay.
Yes.
Okay. Mr. A. Sattar, counsel for the petitioner, as well as Mr. S. Sharma, Danet, counsel for the respondent. Issue notice returnable on 29/1/2024. Issue notice including notice on the prayer for interim relief returnable on 29/1/2024. As the respondent has entered appearance by filing caveat, no steps is required to be taken. As per list on 29/1/2024 for admission hearing.
29, first week of, and the second week of February, any date.
Second week.
Yes.
Just check the calendar is there. Tell us the date.
6 or 7, my lord.
Okay, 7/2. Okay,
7.
caveat discharged. Caveat shall be heard. Okay.
Item 3.
Date di dibo. First case to.
12.
Item 3.
Should be present.
Just a moment. Just a moment. This, Mr. Rai, we are not inclined to entertain this application. Pending condemnation of delay. In urgent cases, the court will have power to to pass an injunction. Then,
But the trial court refused to take up the matter. The impugned order is at page 77. That is what the case is.
oh, acha. Okay, then I'll issue notice.
Worship, there is an IA in this present matter.
We'll have to issue notice on that also.
Worship, if Lordship allows me to just
Yes,
write this.
yes.
So presently the petitioners before your Lordship had filed a suit praying for declaration of right title interest on the basis of an adverse position.
Yes.
And the defendant side appeared and they disputed that the petitioners were in possession of the suit premise. Now, by the impugned order, if your Lordship takes up the IA,
Yes.
in the judgment also, London Trial Court was pleased to observe that the petitioners are in possession on the
Where
basis
is-
of cross
where is that?
examination.
Your Lordship, the cross-examination of the DW1 is at page 46 and Lecture 6. This is type copy and the actual handwritten copy, Your Lordship, is page 49. May I read yours?
Yes.
Says that my father and petitioner's fathers are brothers. We got separated when I was a child. It is not a fact that we got separated in 1980. The petitioner is illegally possessing over the suit land. They got mutated their names illegally. We want the land over which the petitioner name is mutated. The petitioner is in possession of over 4-5 bighas of land. The dispute land is 1 bigha 17 lachar. It is not a fact that I do not know how much land compromises in the suit land. It is not a fact that the suit land is under possession of the petitioner. The house in which the petitioner is residing, it is mutated in our. Your Honor, our position is admitted in this. Now, what has happened, Your Honor, Your Lordship, in this case, on 15/9, the impugned order was passed. We applied for the certified copy on 3/10 and the copy was supplied on 28/11. For reasons best known, Your Lordship, in view of the delay in furnishing of the requisite folios, there was a delay of 47 days, not an intentional delay on the part of the petitioner. Now, what happened on 25/11, taking advantage that there is no appeal, no stay, on page 53, the opposite party tried to dispossess us from the suit premises. We have annexed the FIR, which is at page 53. 25/11. We obtained the copy on 28/11, immediately preferred an appeal along with the application. And Lordship, I have annexed the photographs of the incident which took place on 25/11, which is at page 55, Annexure 8. The Lordship can very well see that they came with these dows and they also came with JCB. Since my position is admitted during cross examination, learned trial court also observed in the impugned order. Lordship, the impugned order I have annexed with the CRP, which is the annexure, was page 13. And at page 19, the learned trial court was pleased to observe that the petitioners are in possession of the suit. Now, the crux of the matter, Your Lordship, is that police is interfering in the matter. Police is saying that since your suit is dismissed, now they are entitled to hold and possess the land. But they did not file any counterclaim in the present. So what we are apprehending, Your Lordship, the urgency, the nature of the urgency, that if we are not protected, we might be dispossessed during this vacation itself, Your Lordship. So that's why I'm praying for an interim order, at least for this ensuing vacation, Your Lordship. Nothing much. So because the date on 6/1, the date is fixed before the learned trial, before the learned appellate court. So when the position is admitted, Your Lordship, the position has to be protected. So the person cannot be dispossessed without following due process. They failed to file counterclaim in the present. So to that extent, Your Lordship, only if they want to evict me, they have to go by process of law, by due process. And the background of the case is that there was a family partition between the brothers. My property, they are occupying. And I am occupying their property. So as per revenue records, the property stands in their name. So taking advantage that the property stands in their name, my lord, they are trying to evict me forcibly, illegally, in view of dismissal of suit and in spite of pendency of the appeal.
Where is your plaint?
Plaint, Your Lordship. Page 29. I also annexed the copies of the sale deed, Your Lordship.
Mr. A.K. Rayat, and counsel for the petitioners. Next paragraph. Mr. Raj, there's a question. You see, in an application in Article 227, I can understand that there is a jurisdictional error committed by the court and we can interfere. But in Article 226 applications, do we have inherent power to pass an order of injunction even under Order 39? Order 39 says in a suit.
Yes.
So it is a well settled proposition that appeal is an extension of suit and therefore we have no difficulty
Yes.
in an appeal. But in 227, when the jurisdiction is only to examine the jurisdiction of the court as to whether the order is within the bounds of the law, do we have the inherent power to entertain an application for injunction?
Article 7.
Well, it says 227. In CPC, the provision is in a suit.
Ex-Deputy Justice, any court, is inherent power.
No, not under 227. Maybe under Article 142.
Any interim order if it is challenged.
We can, you see, what could we do? Let us say ultimately, what we could do. The ultimate power is today, even if you allow it, we can't substitute the order of the trial court. We'll only say that it is set aside and sent back.
Yes.
Do we have the appellate power to pass our own order and substitute the order of the trial court in a 227? That we don't have.
But that is in CRP, Your Lordship. So we are support, we are.
Even in it's same. After that judgment of Salam Advocate Bar Association, and thereafter modified by subsequently Suryadev Rai and then again by a 3-judge bench. It says the power is almost similar.
Yes.
Power under 227 is exercisable similar to that in 115. That is what it said, but it is a power which is lower than 115.
Yes.
So only jurisdictional error it can examine whether it is perverse. So even if we hold today that it is perverse, let us say, presume that ex parte decision we take, it is perverse. What we can only do is that send it back, and we can't substitute the order. Because that is not only the Supreme Court's verdict, but even I have said that in one of the cases that the court does not have power to substitute as in appeal. In appeal, we have powers under 104 that the court can pass any order which may be in the interest of justice. That also is circumstance. The language is 104. Yes, I think that is the power.
Appellate court has ample power.
No, not 104. This
107, Your Lordship.
107. Huh?
107, it's subsection 2 says that the court has
Appellate court same powers
Yes.
and shall perform only same duties as conferred.
Yes.
But this 227 is not there.
227 is being basic structure, Your Lordship, because 115 was curtailed.
No. That's not acceptable. In 227, it's not a basic structure. You don't have inherent right to be here.
Your Lordship,
That is only under Article 32, which says that it's a fundamental right to approach the court. But 227 is a discretionary. We have to first accept that there is a jurisdictional error.
My lord, the law is well stated. Even Your Lordship judgment is there, which says that even if a appeal is preferred along with a condonation application, it can't be sent that the appeal is not in session.
That is jurisdictional error. But what happens today in an interim 227? Can I assume something which is not there in Order 39?
My lord, if I may, my lord, we are praying that even if a jurisdiction is to be, an order of interim nature to be passed, it will be passed under section 151 of the CPC. Because, my lord, if I may place a judgment in regard to restoration of a suit, wherein the emphasis was laid on with regard to the aspect that in view of the dismissal of the suit, whether an injunction order can be passed on. There also the suit is, there the suit is dismissed. But then also there was a detailed discussion, if I may place, your worship.
In 227,
No, in not 227.
no, that we are aware. You see, pending condemnation of application, there is a judgment of Honorable Justice Jain Sharma.
Yes.
We always use that.
And your lordship was also.
Only I
pleased to-
forgot the name.
Yes, it's Ramesh Chandrakal.
Whatever we
And your
forgot the
lordship was
name.
pleased to observe the same in Nalini Gogoi.
No, that's okay. But in 227, exercise of power under 39. I'll come back at 2 o'clock. Let me examine the law in that by that time.
I will also go through it. If there is anything, I will address this.
Because it clearly says 39 rule 1, where in any suit, it is proved by affidavit or otherwise.
My lord, if I understood the question correctly, whether under Article 227, this Honorable Court can pass an interim order.
No. Not under 227. The question is in an application under Article 227, can I assume the jurisdiction under Order 39 rule 1 and 2 and pass an injunction? Stay is something else. I can stay a proceeding, I've got no doubt about it. I can stay the operation of the order, there's no doubt about it. But the question is to assume power and pass a positive order of injunction. Because 39 rule 1 says suit.
My lord, we are not on, my humble submission, we are not on suits because
Come back at 2 o'clock, let me do some research in whatever time I have. Correct?
my lord, but just apprising your worship, I will cover 2, but 141, section 141 says that it does not include a proceeding of an under Article 226, suppose for this. So what we are praying that 39 is inapplicable. 39 does not apply. Order 39. But what I am submitting respectfully for your lordship that under 151. And 151, your lordship, it's an inherent power which need not be confirmed because it's inherent in nature. That is what the judgment of the Honorable Apex Court.
We'll see. Let me examine that point. We are building up well, but since I have to be very sure, we are building up well. Item 4. Yes. Where is the order not complied with?
It's 22.
Page
22.
22.
The tussle of power was between the petitioner and the respondent block.
Just on. Where is the operative part?
Protected part, your lordship will find at page number 6 is the observation of the court, my lord, and then sorry,
Page.
paragraph 6, page number 24.
24.
Paragraph 6. The operative part, your lordship will find at paragraph 8, page number 25.
Yes, now what has happened?
Not, petitioner was allowed to meet his daughter-in-law twice a month. But,
Yes,
he has not been, this has not been, accessed by the respondent. Since the order has been passed on, 2003-2023, when after that, not for a single day, I have been allowed to meet my daughter.
Guardians and Guards Act, G, guardians. You have the Guardians and Wards Act. See subsection 4 of section 43. Subsection 4 of section 43. Guardians and Wards Act.
I don't have this.
You see, under subsection 4, the orders of the court can be enforced. So if an order can be enforced, why a contempt? We close this, we permit you to enforce the order. And say ARD counsel for the petitioner. In view of the provisions of subsection 4 of section 43 of the Guardians and Wards Act, the Learned Counsel for the petitioner craves leave to withdraw this application and move the appropriate court. So, prayer is allowed. This application stands closed with liberty to the petitioner to move the jurisdictional court for enforcement. And is permitted to take the points which have been taken in this application. So stop accordingly. This stop. Okay.
Like.
$27. What is the ground? Just tell us.
The petitioner is staying presently at Shivsagar and her widowed mother is 62 years old. Father passed away way back. And third ground is that she does not have any source of income.
Matrimonial dispute. Mr. S.J. Sharma, counsel for the petitioner. Transfer of matrimonial proceedings. Notice steps within 2 days. Sorry, in course of the day. Today you'll have to take today. In course of the day today. Returnable on
12-2.
12/2. Till the next date of listing, proceeding of so-and-so, page 1 shall remain stayed. Subject to condition that the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court. Take steps within date today. 27.
28.
Oh, sorry, 28.
Item
No.
28.
No representation, pass off for the day. 30.
Item 30.
Then no representation. Foreign George Justin Matheson is adjourned today. List of tenancy vacation, winter vacation. 31. Display photo show kori ase. Mr. Rajbur Bhuiya. Yes. Your matter we are calling. No, I see your name in 31. I don't know, you don't say that.
22 আছে কিন্তু 31 টো আছে
Unless it is a case of mistaken identity. Okay.
Sorry, madam.
No, it's okay. Unless it is a case of mistaken identity.
Waiting for item 20 of the part.
Okay, okay. Then for instance, this matters John to the.
I
Yes, sir.
recommend this matter, my lord. Your
Uh.
lordship put a question here on the question of maintaining.
Okay.
In this case, matter.
We listed after vacation then on the plan made by Mr. MH Borgoya, counsel for the petitioner, list after ensuing vacation, winter vacation. 32.
item 32
Same. It was mentioned John today, list after vacation. 33. Just
liquid
yes, where is the order?
Sir, page 30.
30?
Page 30.
30.
I'm aggrieved by the paragraph 4 of the lordship.
But what is wrong in this?
Page 21 is my wakalat number.
21. Where is the plaint?
Same at page 13. And lordship, the prayer portion is at page 70, in which the prayer against the government respondents is only to the effect of correction of land records as per the.
No, no, you see, that will be difficult. The court has rightly done it. You see, somebody makes rightly or wrongly government a party. He is a defendant. The government advocate cannot come and represent the private party also. There will be clash of interest.
Lordship,
We don't know. You see, it may be a case that only correction of land required order is required. But ultimately, he is the government advocate.
lordship,
He can't represent both interests.
the wakalat number, he is not the only advocate, he is also.
No, no, but this is improper. That also we don't permit. We also ask questions. You see, there are learned counsel who appear for the state also. Some of them are CGCs also. So when it comes to a notice that he is both, so we ask them always. In my courtroom, at least I ask, you will be appearing for so and so also. Then they realize and say no. You see, there may be a clash of interest, we don't know. But a lawyer can't be permitted to hold both the briefs.
Thing is, I'll just take instruction whether he can appoint other advocate, because he has been directed to appear personally. And due to his unavailability, he is not being able to appear.
30. Page 30.
Last part. All that defendant number 1, 2, and 3 are directed to appear personally. 2 and 3 are out of station, your lordship. Even they could not file this CRP because they are ill and they are undergoing treatment somewhere else. So not within the state. So if they can find an wakalat number and appoint some other advocate, I'll take instruction and then they can. Direction is to appear personally. Second last paragraph and the last paragraph.
We are closing with liberty to you to approach again if adverse orders are passed. We'll permit you to file an application for what you call dispensation of personal appearance. But insofar as this order is concerned, I don't think it is an incorrect proposition. You see, because there are several things which come into play. In this court also, we a long time back, I think it was in 2003-4, court issued a notice that as to why Advocate General should not be appearing in bail matters, even in private capacities. Those orders we have seen.
Understand it
So
is not
because
proper.
if a person is also holding the such a high position and appears in a bail matter, although what you call, there is no otherwise no bar, but this court posed a question at one point of time.
You never know what unfolds when the trial.
No, it's not that. It's
The state is made a party.
is the institution which you have to think of. But Mr. Vijay Mukherjee, learned counsel for the petitioner, by filing this application under Article 227 of the Constitution of India, the petitioners who are the defendants in TS 23 or 2021 have assailed the order dated 7/9/2023 passed by the learned civil judge within bracket junior division bracket closed number bracket closed Kokrajhar in the said suit. Disallowing the learned government pleader to represent the private parties in a suit where the government is also a party. First of all, the petitioners are aggrieved by direction contained in the said order for personal appearance of the petitioners who are defendant numbers 1, 2, and 3 in the said suit. Just a moment. Joseph, I asked the actor to appear personally on the next date. Next, Farah. The narration narrated above shows that the government pleader had appeared both for the government as well as the private parties. First of, insofar as the said part of the order is concerned, the court does not find a legal infirmity in the said order, as there is a possibility of clash of interest in the two sets of defendants. So therefore, in respect of the said part of the order, disallowing the government pleader to represent the private to the petitioners in a suit where the government is also a party, does not suffer with any jurisdictional error. Next, insofar as the direction to the petitioners who are defendants, defendant numbers 1, 2, and 3 in TS 23 or 2021 is concerned, the court is of the considered opinion that this issue can be raised before the learned trial court by appearing through another set of counsel and paying before the court for exemption of personal appearance. First of Therefore, the court is inclined to close this matter by granting liberty to the petitioners to move the court for exemption of personal appearance in a civil proceedings and to appear through the learned counsel. First of, if such an application is filed, the court has no doubt that the learned trial court shall examine the same and pass appropriate orders thereon. This application stands closed with observations as indicated above. Without issuance of notice on the respondents. Acha, you are there as government advocate. The government is a party here? No, okay.
If it was some, it
34.
in this case, I have filed a contempt for
Where is the order?
what are my lord executing court, kindly see page 32.
32.
Court pass an order directing the deputy registrar registration Kachar for registration of sale deeds. Then on page 33, the same authority has sought for 2 months' time for registration. And on the
There is a reason. I think you will adjourn it for some time. This is happening also in Guwahati. You see, what has happened was, this I am aware because this matter somehow we have discussed the matter with the authorities. What has happened is, in the entire state of Assam, before all the registration offices, there has been extensive raids to catch up those what you call middlemen. And so the practically all registration is now closed, and the police is investigating those registers and all in every district.
Here in this case,
No, that's okay.
question raised that the value which has been assessed, that is less. That is why registration is rejected at page 37. But value is more.
37.
Shown. The value is
No, then you see,
5 lakh.
no, you
We
see,
have 19 lakhs.
no, that
we
may
have-
be, but you see, under the revenue laws,
Yeah.
it is the government DLR district level rate value on which you will be paid. You see, you can sell just like what happened in respect of a.
I have understood,
Huh.
my lord, but here in this case, this is not the case. That is why I am page 37. Here in this case, value is, I have quoted more value than the
Where is that?
page 37.
I'm there at 37.
With reference to above, I have honored to inform you that as per report of the concerned ASO, name of seller and father's name of the seller is not found in the record.
Yes.
This is also incorrect. Why I am showing? This is tenancy right has been sold. Not the, this name has reflected in tenancy Khatian, in the Khatian. And regarding second part, moreover, no class of land is mentioned in the schedule of the land for which the zonal valuation approved by the principal secretary, revenue and disaster management cannot be ascertained. And therefore, decretal sale deed in title execution number so and so is not registrable as per section 27A of the Assam Amendment Act of Stamp Act. stamp, I have proper stamp value I have given. The value has been assessed 19 lakhs.
I think then, you see, if that is the case, then you'll have to come in, not in contempt jurisdiction, but in a writ. You see, contempt is only willful deliberate violation. If the authorities feel that the revenue is escaped and they don't register it, they have a reason not to do it.
Yeah, they have reason, but here in this case, this is not the case that I have escaped.
No, but
the
that,
revenue.
that we can't examine in the contempt jurisdiction. Contempt is willful violation.
But in earlier letter, can we see? Earlier letter at page.
So you can challenge this order, we can set, stay it and get it registered for execution of the decree, because the problem is, you understand, a willful violation. If the revenue examination is made,
Page 33, can we see? Earlier, stand was that we required 2 months time for registration.
yes,
Now this letter has been issued that we cannot register the same.
so they have given a reason. They have given a reason. Let us say today, you see, I get a decree. That very unique decree I get. At Guwahati, I get a decree that the Taj Mahal belongs to me. Let us say I say I'm in a.
Then I have no title, I entered into.
So I get it. So registration is something, they say that no, this is a heritage building. And therefore we are not intending to do it. So they have given a reason. So it can't be a contempt. Because in contempt, I have to close it, that is not a willful violation. Willful violation is that you give them, they don't do anything, they don't register you, they hunt you out, but here they are giving a reason. They have.
Order passed by the executive court order.
No, that's not violation. They are writing into it that you have passed a decree, but we are unable to do it. Uncompliable, you see, every decree, some decrees are there which are inexecutable.
Reason is given that as per Assam Amendment Act, the value has been improperly.
That you can challenge and we can order that, because there is a.
Suppose value is.
No, Mr. Ghosh,
improperly assessed.
you see, I'll tell you, simplify things. Because there are orders which says that when a decree is passed, those permissions are not required. Even our court has given a judgment where when these are, there is a decree of the court, it has to be registered. So we can, this can be enforced by that. But if you see a contempt, dispassionately you sit there, you don't, you come out of that brief and then think over. If there is a order of the authorities which says that it can't be done, and let us say we accept this, for example, let us say we for a time being, we accept this proposition. Then what happens? The decree becomes an inexecutable decree. When there is a revenue loss.
If it is an inexecutable decree,
No.
can the authority then?
No,
the
you see,
revenue
in a
authority-
contempt, Mr. Ghosh, in
revenue
a
authority
contempt,
can-
please understand,
No,
please understand my perspective. Please
Please.
understand my perspective. You see, in a case where revenue loss is alleged, in a contempt, I can't force them to do it. Because by way of a contempt, I cannot allow an illegality to prevail. That is first principle. Second principle is that if I am to decide the issues of the correctness of the revenue authorities have to be there. They have to be issued notice, because when they are saying it can't be done, therefore they are taking the responsibility of not being able to do it for certain reasons. They are communicating why they are unable to do it. So in that circumstance, if we force them to do it, this is the second perspective. The third perspective is that when the authorities are refusing to do it, that it can't be valued. So we need to ask the revenue authorities to tell us if it is right or wrong. Rightly or wrongly, they have passed an order. It's not that they have not shown courage. They have shown courage and they have informed the same court which has passed a decree. They have also informed it to the district judge that, look, we can't do it. This is the reason. In light of that, can it be a contempt? Let us say in a case.
It is said that not registrable as per.
So they have done it. It's inexecutable decree. It becomes an inexecutable decree. So that order has to be challenged. In a contempt, we can't accept a challenge. In order, we'll only see whether the default is willful or not willful. And if they have shown a reason, we can't touch that order saying that it is illegal. In a contempt, I can't issue a direction, positive direction or a negative direction. I can merely say to comply or send him to civil imprisonment.
This order has been passed by the learned executing court, page 34 can be seen. The
I've seen
executing
that
court
now,
passed the
I've
order.
seen that.
Executing court passed the order. I have come up with the contempt that the authority has not been comply the order of the executing court. I have not come against that he is to be passed any order. It is the executing court's order has not been compliant.
Okay. I'll be closing this matter. Heard Mr. S.K. Ghosh, done counsel for the petitioner. By filing this application under section 10, 11 and 12 of the Contempt of Courts Act, read with article 215 and 227 of the Constitution of India, the petitioner has alleged willful and deliberate violation of the judgment and decree dated 21/12/2022, passed by the learned civil judge number 2, civil judge within bracket senior division, bracket close number 2, Kachhar in Silchar, in TS 130 of 2022, next, the petitioner, who is the decree holder in title suit number 130 of 2022, is holding a decree passed in the said suit whereby the defendants in the said suit were directed to perform their part of the contract and register a final sale deed in respect of the suit property in favor of the petitioners dash plaintiffs. And they were directed to deliver khas possession of the suit land to the petitioners. Full stop. The decree was put to execution by filing title execution case number 3 of 2023. And in the said proceedings, by an order dated 15/5/2023, the learned executing court had directed the petitioners dash decree holders. So only one petitioner, not two. Petitioner, singular. Petitioner to deposit the requisite fees for registration in the office of the deputy sub-registrar's office. And for receipt of sale deed after registration. A date was fixed. Full stop. The said order was communicated to the office of the district registrar Kachhar and the deputy registrar Kachhar by a letter dated 16/5/2023, sought for extension of 2 months' time regarding registration of the decretal sale deed. Full stop. Next, thereafter, the learned executing court, by an order dated 20/5/2023, granted extension of 15 days' time for registration of the decretal sale deed, fixing another date for receipt of receipt of decretal sale deed after registration. And thereafter by an order dated 15/6/2023, by rejecting a contempt petition, copy of the order was sent to the deputy registrar within bracket registration for necessary action, fixing another date for receipt of decretal sale deed after registration. Stop. Thereafter, the district registrar Kachar within bracket registration, bracket को Silchar, by a letter dated 25/7/2023, wrote to the executing court as follows. Page 37. Quote this. Next paragraph. As we are in, as the court is presently exercising contempt jurisdiction, the court refrains itself from entering into the merit of the communication dated 25/7/2023 passed, issued by the district registrar Kachar within bracket registration. Stop. Next paragraph. Nonetheless, having taken note of the contents of the said letter as extracted herein before, the said authority has given an explanation of why the registration cannot be done as per section 27 within bracket small a bracket close of the Assam Amendment Act, 2004 of the Stamp Act. Full stop. Next paragraph. In view of the explanation provided in the said communication, the court does not find that this is a case of deliberate and willful violation of the orders passed by the learned executing court. Stop. Having said so, court is of the considered opinion that notwithstanding that the court is not inclined to entertain this as a this contempt application, yet it would be open to the petitioner to make a challenge to the communication in an appropriate court of the forum, and it is provided that this order shall not be a bar for the petitioners to make a challenge to the said communications in the event they are aggrieved by the two communications referred above, being communication dated 16/5/2023 by the deputy registrar Kachar within bracket registration and communication dated 25/7/2023 within bracket issued by the district registrar Kachar within bracket registration.
Not agreed with 16.5, I am not saying.
No, I'm saying both. If you are agreed by that also, you will still make a challenge. Okay, then first person not required, only second one, 25. This application stands closed. We are taking up bail matters out of turn because by the end of the day, I'll have to sign it. Yes,
Item 35.
35.
I am the driver, Your Lordship. I have.
Just a moment. Where is that? Just a moment. Where is the FIR?
Definitely, the page number 10, Your Lordship.
10.
10.
Yes, what did, you have the case diary? What does it say?
Lordship, here it is, here the statement is recorded, Lordship. He has stated that he has also involved in other activities, in such kind of activities. But my lord, my contention is that the main thing is that at the relevant point of time, he was unable to produce any documents, Lordship.
But you have seized the cattle.
Lordship.
Then release him then.
Other-
Mr. Your name?
My name is Dhyan Shah. My humble submission, Your Lordship. The owner of the vehicle and the owner of the cattle has already reached on the.
Oh, you want to argue on merit?
No, Lordship, I am
Yeah.
only the driver.
No, please be alert in the courtroom. I am allowing it and you are arguing. Yes. Khan counsel for the petitioner and Mr. K.K. Das, Leonard, APP for the state. By this application under section 439 CRPC, the petitioner, namely so-and-so, who has been arrested in connection with Sonapur PS case number 256 of 2023, corresponding to GR case number 8654 of 2023 under section 379/411 IPC, read with section 11 within bracket small a, again bracket small b, and again bracket small d of the Prevention of Cruelty to Animals Act, read with section 13 within bracket numerical 1, bracket closed, oblique 14 of the Assam Cattle Preservation Act, seeking regular bail under section 439 CRPC. Next, the learned APP has produced the case diary and has opposed the prayer for bail. Next, the case diary reveals incriminating materials against the petitioner of transporting cattle illegally without any authorized permit and without any supporting documents. Moreover, the IO is also suspecting the petitioner to be involved in several other cases of similar nature. Next paragraph. Be that as it may, the petitioner has already been in custody for last how many days? 30 days. And it appears that his statement has also been recorded. And the cattle has also been seized. Cattle in the truck has also been seized from the court is of the considered opinion that further custodial interrogation of the petitioner may not be necessary, and accordingly, court is inclined to release the petitioner, namely so-and-so, on bail on his furnishing of bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate, Kamru Metro, Guwahati. The bail is granted on the following conditions. Give that conditions. Just add one more thing. In the event the IO finds that the petitioner is involved in any similar offense, it would be open to the IO to move the jurisdictional court for cancellation of bail. Okay.
Item 36.
Make either lord.
Yes.
One of the 438 application matters. Page 12 is the FIR matter. This is the FIR is that matter.
Page FIR is page.
Page 12 matter. From the informants matter, the company matter, some chemical fertilizers were found to be delivered in Amar Breeze Bandar, matter, Mazga. But it was delivered matter to the petitioner's stock matter, Amar Breeze Bandar, matter, Sabji Mandi, Barpeta. It was matter wrongly delivered. This is the case matter.
Government subsidy fertilizer. No, it's subsidy fertilizer.
But that is not contained here, my lord. But it is chemical fertilizers which were bound to be delivered somewhere. It is delivered, wrongly delivered here, and the petitioner has not returned. Was found to be delivered in Amar Bridge Bhandar, Majgaon, but it was delivered Amar Bridge Bhandar, Supplementary.
Was it recovered?
Lordship, it's not recovered, Lord. They have not delivered. They are holding it.
Then we'll have to refuse your bill. It can't be registered if it has not been recovered.
What happened, Manoj, the petitioner is, he has not appeared also before the I1 because of.
That is okay. You see what they conduct. When the FIR says that it is not your product and you are having it. And it's okay. You see, wrongly delivered also, Mr. Abdullah. When you say these things, since I come from a different background, not from the west side, from the slightly eastern side of the court, you see, Section 70 of the Contract Act comes into play in my mind, that even if it is wrongly delivered, you'll have to either pay for it or return the goods. You can't, we'll take it up on, because you take instruction, we'll take it up at 2 o'clock. No, by 2 o'clock, we take it up. You take instructions from him. If he's ready to return, we'll grant you bail. The value of the goods he is ready to return as a condition for grant of bail. Correct? At 2 o'clock.
Item 37.
Nobody is there?
It is available.
Okay, take up later on. Just give the case ID. $38. Not available. You are on interim bail. No, you are on interim bail. Okay. Both sides are represented. Mr. K.K. Das and APP takes some more time to obtain the case diary. Prayer is allowed. Interim bail granted to the petitioner by order dated 14/11/2023 stands extended till the next date of listing. List on so and so for production of case diary.
25.
25/1. 25/1. No, don't make it 25, make it 24/1. Okay. 39.
Item 39.
38 application. Page number 11.
Page
11 versus page number 16 now.
16.
আপোনাৰ জনাও যে প্ৰথমে শিক্ষা খণ্ডৰ অন্তৰ্গত 542 নম্বৰ লাহনীবাৰী প্ৰাথমিক বিদ্যালয়ৰ প্ৰধান শিক্ষক শ্ৰী কনক গগৈ ছাত্ৰ ছাত্ৰী সমাজক ক্ৰয় আৰু বিতৰণৰ ক্ষেত্ৰত বিত্তীয় অনিয়ম কৰাৰ অভিযোগ আনিছে ঢকুৱাখানা প্ৰশাসনে অভিযোগ মতে 2022-23 বৰ্ষৰ 19 জন ছাত্ৰ ছাত্ৰীৰ বাবে ধন আবণ্টন হৈছিল আৰু প্ৰধান
Okay, just a moment. Yes, what is the case diary?
There is an inquiry report is there.
Just pass it on.
Basically, I have additionally purchased 5 number of school uniform and besides that same and 2 number of ceiling fan has additionally purchased. And only because of that lots of poor infrastructure of it, same 2 number of ceiling fan has remained in my office lots without fitting lots. And I.
No, no, you see, you are the headmaster. You see, you are the headmaster.
Yes.
Just think of it. I give a requisition, this pen has, what you call, the ink is not there. I requisition a pen from the courtmaster, and he gives me 2 pencil. You see, this is somewhat a costly pen. So this is something which I am requiring, and he gives me 2 pencil, which are 5 rupees each. Just,
This matter I have already been informed all the villagers and managing committee lordship.
oh, villages, we are not bothered. You see, even if the Gambura says that, please excuse the courtmaster, and this pencil is good enough.
Besides that same lordship, I am only the in charge headmaster lordship.
No, no, you see, nowadays the technology is high.
The CRC officer has.
No, nowadays there's a different technologies. You see, nowadays we have pencils which are used in space, and they are very costly, and they are, these are called, there's a new name of it. It's pencil and pen both. Infinity. It can last your lifetime.
Additional 5 number of.
No, that's okay, but you see, I'm putting a question.
2000 lordship. But lordship, in my academic session lordship, it may presume that lordship, more students will come to my school lordship from 1 to 5 consisting in 5 number of classes lordship. Then lordship,
Oh, that is very
more
dangerous.
students, lordship.
That is very dangerous. That is more dangerous than what the offense is. You see, I know, you see, I can understand a very rich country saying that for future prospects we are doing this. I can understand. But India is not such rich that we'll have infrastructure created for things which are not happening. Now let us say, for an example, I give an absurd example, I am good at it. Now you see, we are proposing that we should go to North Guwahati in a bigger campus. Correct? Now this is likely to take 10 years time. By the time maybe I would have superannuated, maybe some of you would have become senior in age. Correct? And now we say that since we will go there at 10 years, now we have money, let us purchase fans. Let us purchase computers. I'll keep it ready after 10 years when we go there. Immediately we'll have computers to be installed there. Intention is very good, but is it acceptable?
No, sir, intention.
Have you purchased a suit for what do you call? No, have you purchased a uniform for your children who are still school going or college going?
3,000 rupees amount in.
I'm asking a question to myself.
If I
Just,
go
no, I'm just asking a question to myself. You see, my son will become a lawyer in 5 years' time. So should I?
President has realized, former President Lordship, Dr. Sarvapalli Radhakrishnan Lordship, about the diesel Lordship. Therefore, we have add on to that.
To have uniform for children,
I have not such a
no,
intention, Lordship.
we will have to
And
refuse it.
your Lordship
We'll
is
have to
already
refuse it.
of
No,
it,
no,
Lordship. By
no,
this
no.
right. Can you pay his Lordship? Coexist has already released on bail.
Sure.
Can you pay it that it is valid, Lordship? In any condition, I will be released on bail, Lordship. I will be communicated with the investigation officer, Lordship. Even Lordship 41 a compulsory Lordship notice Even it's not upon me as on today, lordship, despite passes away 2.5 month, lordship.
Okay. What we'll do is that we'll grant him bail. We ask him to deposit 20,000 before the IO. Correct, as a bail, as a bail bond. That money would be transferred to the state treasury. And in the meantime, we will cooperate with the investigation. We call for the case diary again after 4 weeks. That 20,000, I think, would be sufficient for the reimbursement to the government. Heard.
Mr. Answer.
Mr. M. Saikia, counsel for the petitioner. And Mr. K.K. Das, learned APP for the state. By filing this application under section 438 CRPC, the petitioner is seeking PRS bail in connection with Dokuakana PS case number 132 of 2023 under section 420 of 406 IPC. Next para, the petitioner is the headmaster, within bracket in charge, of 542 Lahibari, Lahibari LP School. Full stop. As per the allegations in the FIR, lodged on 17/10/2023 by the who has lost it?
Inspector of
By the inspector of schools,
Dokuakana.
Dokuakana, comma. No, sorry, BED, Block Elementary Education. Sorry, District Elementary Education Officer.
As per PA instruction of district elementary education officer, lordship, block elementary education officer has launched an FIR, lordship.
Block Elementary Education Officer. Okay, then it will be BEO, Block Elementary Education Officer, Dokuakana, and lodged an FIR, alleging that 19 school uniforms were sanctioned for the financial year 22-23, but only there were only 14 students from class 1 to class 5. And that out of 5 ceiling fan purchased by the petitioner, only 3 of them are in use in the school. Full stop. The next part, the learned APP has produced the case, Mr. K.K. Das, learned APP has produced the case diary and has opposed the prayer for bail. And on perusal thereof, it appears that there are incriminating materials against the petitioner of misappropriating 5 sets of uniforms and 2 ceiling fans. Next paragraph. Having regard to the nature of offense, comma, and taking note of the fact that the petitioner is serving as a headmaster in charge of the school, comma, the court is inclined to grant an interim bail to the petitioner for a sum of rupees on his furnishing a bail, interim bail to the petitioner by providing that in the event of arrest of the petitioner in connection with the petitioner, namely so and so, in connection with the aforesaid case, comma, he shall be released on furnishing a bail bond of rupees 20,000 in cash. To the cash. First, on receipt of such money from the money as bailer from the petitioner, comma, it would be open to the arresting officer or the officer in charge of Dhokakana police station to remit the money to the government treasury. Which will be held till the further orders of the trial court if for further orders of the court, until further orders of this court. Next paragraph. The interim bail is granted on the condition that the petitioner shall appear before the IO of Dhokakana PS case number 132 of 2023 within a period of 10 days from today. And on such appearance and on and shall cooperate with the investigation. The learned APP, next paragraph, the learned APP shall send back the case diary and obtain the case diary on after a month, give a date.
2nd February.
2nd February. 2nd February. Okay. To 2023. 4.
Thank you.
This is Gaonpura adjudication. Yes, what is the case diary?
Regarding Lordship 325, there is no external injury found, Lordship. And moreover, if I look into the 161 statement and 164 statement, in the 164 statement, if I go through it, Lordship, it seems to be that he is just intending to, but has not done anything, Lordship. And in 164 one statement, there is no specific allegations are not like that. I mean, Lordship.
What has happened, the byline which leads to my house is often been blocked by this complainant. He used to do shooting and all these things. And now and then, there was some exchange of words. And in the incident also from morning till 11 or 11 p.m. He blocked the road, making us unable to go and to our house. And that is why Fatas initially with male members, and thereafter these ladies came, and nothing of this allegation, hearing clothes and all these things.
However, complainant has stated that mishandling. Complainant has stated that mishandling, but our statement, Lordship, I have not informed of it.
Neighboring witnesses were
Just a moment. But the place is their house, you are the aggressors.
His house is on the front side of this byline. My house is towards the.
No, but the incident occurred at the house of the informant.
He blocked the road in front of his house, so that people cannot enter in the byline. That is why. Because he used to carry out this shooting and all these things in front of his house, my lord. That byline leads to my house, my lord, and the other co-accused person. Every now and then, my lord, it was, my lord, on several occasions, I asked him not to do these things, my lord. On that day, my lord, till morning, till 11 a.m. PM, sorry, my lord. This continued, my lord, and that is one. He's admitted, my lord, Balmain notification, my lord, I admit that, my lord. But so far as hearing of clocks and all these things, this is absolutely false. And in FIR, my lord, they say that all the accused persons tried to, my lord, clear the clocks, and but in 164, possibly I have been, my lord, targeted because I was the first person to raise objections on that day. And some neighboring people
That's
who are
not-
present there. For the FIR itself.
That's wrong. What are the name of the names of the accused?
There are 6 numbers, but I am for one, accused number 1, my lord. Yes,
Who are the other co-accused? Just give me the names.
Mujahid Islam, my lord.
Then
Sahabat Khan, my lord. Mujibur Rahman, Ashikul Islam, and Karimul Islam.
your house is not there.
My all the residents of Rupnagar, my lord. The same
But
location.
then your house is not there.
My-
Your house is not there in that locality.
They are from the same local.
But then you are aggressors, you are not the residents of that locality.
But my house is at the end of this valley,
No, it's not there.
but as I have been instructed, madam. Because every now and then he used to block this road, madam, and causes inconvenience to the public.
You see, this is the sketch map. Sketch map doesn't have your name, just show it to him if his house is there. This house is not there. Because if your aggressor is going at 11:30 in the night and attacking people in their home,
Possibly in the statement. The sketch map. Well, sketch map particularly, they used to, madam, go by the place of occurrence, madam, so far as I understand, madam. But it is a fact that, madam, my house is at the end of the valley, and that I have specifically stated in my petition also.
where is that?
Para 6, madam.
Para
Para 6, madam.
6.
5 and 6. Six to be more precise, madam.
Okay, grant them bill then. Mr. N.J. Das, counsel for the petitioner, and Mr. K.K. Das, London APP for the state. Next, para, the petitioner who is apprehending arrest in connection with Gwalpara PS case number, so page 2, is paid for previous bill under section 438 CRPC. Next, the London APP has produced the case diary and has proposed the prayer for bail on the ground that the petitioner is the one of the aggressors. Next para. On a perusal of the case diary and taking note of the nature of injuries suffered by the persons or the informants, apostrophe as informants side. The court is of the considered opinion that custodial interrogation of the petitioner may not be necessary. And accordingly, the court is inclined to release the petitioner, namely so and so on bail on his furnishing a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate. Sorry, this will be AB. Or the arresting authority. The bail is granted on the following conditions. It will appear before the IO within 10 days from the date of the order, failing which this prior bail shall stand lapsed with by effects of time. And the prior bail order shall lose its efficacy. Bail is granted on the following conditions. This prior bail is granted on the following conditions. Appear before the IO within 10 days.
Fine.
Case diary is returned.
Deeply obliged. I'm available.
Form 41.
May I plead your lordship? My lord, this is a anticipatory bail application, my lord. My lord, the issue involved in the case is between my lord brother and sister, my lord. The sister, my lord, informant, my lord, he along with her son in the during the Satpuja time when
Just a moment. Just,
separate face.
just a moment. Just give me 2 minutes. Where is the FIR?
Separate page 15, my lord.
15.
FIR, my lord, the informant has not mentioned that my lord accused her brother, my lord.
Okay. You have the case diary? Pass it on.
My lord, what I am submitting, my lord, at this stage, custodial interrogation is not necessary because my lord, the petitioner have already appeared before the IO. Their statements have already been recorded, my lord. And my
Just
lord,
hold on.
350
You have appeared before the IO?
Yes, madam. And their statements have already been recorded, my lord.
You are appealing for the informant? What is the name of your younger son, Durga Agarwal's younger son? Where is your copy of your complaint before Borolimu police station? Where is that?
That is, my lord, that annexer to page 17, my lord. Originally, that page 18, my lord. That has been duly received by the Borolomo.
Annexure?
Annexer to page 17, my lord. Originally, at page 18, my lord. With the seal of the Borolomo police station. The language are not so clear, my lord. Because Because, my lord, when they reach the Borolomo police station, the police personnel advise them that it is not within their jurisdiction. So they advise them to go to the local police station and to file FIR, my lord. Then they, my lord, took the boy, and on their way, my lord, the police.
No, but you see, you don't have a right. This can't be done. It cannot be permitted in a civilized society.
Yes, my lord, that is true, my lord. I admit, my lord, but that is true. And thereafter, my lord, they have been taken to the police station, my lord. Their statements have been recorded.
No, we'll have to order inquiry by a highest, what you call, police authorities. Even in bail matter, we'll assume jurisdiction and we'll send it for inquiry. This can't happen in a civilized society.
My lord, because it has happened because the boy is the nephew of the petitioners, my lord. And my lord, as a matter of fact, my lord.
So, what has happened is absolutely, what you call, it just can't be accepted.
My lord, as a matter of fact, my lord, the boy, Manish Jain, my lord, at the early, because their father expired at their early age, my lord, and his entire expenditure of study and everything was borne by the petitioners only, my lord. So
No, you see, the question is, having done so, who asked you to do it?
On their own, my lord. My
So,
humble.
that's not, but what you are doing is extrajudicial. That can't be done.
Yes, my lord, my FIR has been registered, trial will be there, my lord. What I am submitting that.
No,
we'll
have to get it suo motu registered as a, what you call this, this should be taken up as a, take suo motu cognizance of this.
Yes, my lord, but my lord, since their statements have been recorded and he has been recovered, my lord, so their custodial interrogation, my lord, at this stage is not
He'll be
required.
entitled to bail because he has appeared before the IO, but this
is
we'll
my-
have to take up separately.
Yes, my lord, that may be done, my lord.
No, it is there. No, that is different. You see, but the custody interrogation is not necessary because of the fact that
Possibility of hampering the witnesses. One submission.
no,
Next
no.
submission, your lordship can see their affair in their affair, annexure 7, my lord, with the bail application. Annexure 7, my lord. They admitted that they have taken away the boy from how possibly illegal. Police has detected him and
No, that is there.
from their position at Agia.
That is there, but
Page 24.
no, that is admitted. He is not denying that. He is denying that, and he says that he took the boy and produced him before the police station. Borolomo police station, if he is produced. But the question is that this is extrajudicial, what you call, steps in their hand. That we have to take cognizance of this in an appropriate jurisdiction.
Yes, my lord, that may be done, but in this case, my lord, what I submitted.
Bail will be granting it to you, but we'll take up this matter as suo motu appropriate jurisdiction, suo motu. Bail will be granting, but we'll examine this issue. But Mr. D.P. Baral and counsel for the petitioner, as well as Mr. K.K. Das and the APP for the state. Also heard Mr. N. Adam Leonard, counsel for the informant victim, who has also filed an objection to the prayer for grant of bail. Next para. The petitioners who are apprehending arrest in connection with dispute PS case number 2214 of 2023 under section so and so have paid for pre-arrest bail under section 438 CRPC. First of all, as per the FIR lodged on 26/11/2023, the petitioners had entered into the house of the informant, assaulted them, and also took away the son of the informant. At around 10:30 a.m. on 26/11/2023. Next para. The learned APP has produced the case diary. Next para. Before referring to the case diary, the court is inclined to record the stand of the petitioner, record that the stand of the petitioners in this case is that they had picked up the son of the informant from the house of the informant and dragged him to Borolimbu police station on an allegation that some money was stolen by him. Give the name of full stop. On being asked, the learned counsel for the informant has submitted that the name of the son who was taken to the Borolimbu police station was Manish Jain. Next para. The petitioner projects that on 26/11/2023, the petitioner number 1, namely Daulat Ram Shirania, no, sorry, 3, number 3, petition number 3, Daulat, DAULAT, next word RAM, next Shirania, CHIRANIA, had submitted an information dated 26/11/2023 to the officer in charge of Borolimbu police station seeking permission to go to the house of Manish Jain. Full stop. And it is projected that after informing the police, the petitioners had went to the house of the informant and picked up her son. Next para.
They picked up the son and then came to the police station.
Police picked up the son.
No, the petitioners, my lord, they first went. to
That is
the-
what I am saying.
Yeah.
That is what I am saying.
They picked up the son and came to the police station.
That's what I am saying. Full stop. Next para. On a perusal of the case diary, it appears that on that pursuant to notice under section 41 capital A CRPC, the petitioners have appeared before the IO and their statements have been recorded. So we also find that the officer in charge of Udalbakra outpost on 27/11/2023 produced the victim of kidnapping as well as no, that's not required. Don't say that. No, 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 no. Case diary also reveals that pursuant to notice under section 41A CRPC, the petitioners have been examined by the IO and their statements including the statement of the victim has been recorded. From the statement of the petitioners before the IO, it appears that not only the victim was taken to Bharalima police station, from there, he was being taken to Goripur, and in the meanwhile, the police personnel from Agia police station, AGIA police station, had intercepted the vehicle and the victim was recovered. So, next, therefore, it appears that there is quite a high-handedness in the actions of the petitioners who have taken law in their own hands to kidnap a victim from the house of the informant, then taken to Bharalima police station, and then shifted to Goripur, and in the meantime, in view of the FIR lodged, the vehicle was intercepted at Agia police station and the victim was recovered. So therefore, it is demonstrated that the petitioners have the ability of taking law in their own hands with active connivance of the police personnel. Such a high-handed approach is definitely not in the interest of the justice, because the court cannot put its seal of approval to a private citizen being empowered to catch hold of accused and then kidnap him from the house and take wherever he wants. Full stop. This action of the petitioners defies the rule of law and cannot be encouraged. Full stop. Therefore, notwithstanding that the petitioners have appeared before the IO and their statement is recorded, but their conduct discloses that they are hand in glove with the police personnel. Full stop. This, in the considered opinion of the court, disentitles the petitioners of PRS bail. Full stop. Next para. Under the circumstances as narrated above, as the court finds the petitioners have connection with the police station can inform the police that they are going to pick up a person and take law in its own hand by kidnapping a boy aged about, what is the age?
19 years.
19 years. Take him to a different jurisdiction and a different district and jurisdiction, comma. Not only the court finds the petitioners entitled to appear as bail, but it also appears that this incident is also required to be examined in a different jurisdiction of this court. Next para, therefore, comma, notwithstanding that the petitioners have appeared before the IO and statements have been recorded, comma, but the act of kidnapping in connivance with the police is found to disentitle the petitioners to appear as bail, so accordingly, prayer for appear as bail is refused. Next para, let this matter be examined by the registry of the court, and the act of connivance of the petitioners with the police personnel of Baralimur police station, allowing kidnapping of a person from his house at Guwahati and taking him to Gauripur is required to be taken up by the court in appropriate jurisdiction. Full stop. You see, as a suo motu matter. Next, but accordingly, let this record be brought to the notice of this order, and the record be brought to the notice of the registrar within record judicial to examine whether suo motu cognizance of the incident of kidnapping can be taken by this court, which has been done with the comma, which has purportedly been done, comma, as stated by the petitioners with connivance of the Baralimur police station. Next para, let a copy of this order be also sent to the Director General of Police, Assam, as well as to the Secretary, Government of Assam, Home Department, next para, bail is refused, case diary is returned. Yes. Forty-two. Charges submitted.
My lord, here, my lord, this is a bail the FIR, my lord, is of 2016. This pertains to the APSC, my lord, combined competitive examination, my lord. Now, my lord, after submission of charge sheet, they are again arresting people. The indication again, if my lord comes to the forwarding report.
This is a appear as bail application.
Yes. Forwarding report of other accused, my lord, at page 19.
Page?
Page 19, my lord.
Yes.
This is a forwarding report of two other accused persons. One of which, in the reference, one of we see Dibrugarh PS case number 936 of 2016. Now, one of me come to the next page, the grounds of arrest. Grounds of arrest, my lord, on the next
Page?
page, page 20, my lord.
20.
Well, on serial number 2, during primary interrogation, they have accepted that they have used illegal means to increase their marks in CE 2013 by insertion of fake answer scripts into their original answer scripts. That is, serial number 3, my lord, that clearly revealed that duplicate sheets were inserted in the answer scripts of political science so and so. Now, my lord may come to serial number 7. My lord, 4 is also similar, my lord. 4 is in respect of one accused, 3 is in respect of another accused. Number 7, my lord. The accused persons are arrested to ascertain their appearance before the honorable court whenever required. Why not?
Were you arrested earlier?
No, my lord, I have not been arrested. My lord,
Then,
my lord, the apprehension, my lord, in respect of the petitioner is at page 22 and 23. 22, my lord. A show cause notice has been issued to me, my lord. And thus, my lord may come to the statement of allegations at page 23. Paragraph 2, Sri Vikas Sharma, Assistant Registrar of Cooperative Societies, now Deputy Registrar of Cooperative Societies, Jorhat, is a beneficiary of the anomalies and malpractices carried out by the APSC. He got recommendation by the APSC for appointment by enhancement of his originally scored marks in the final tabulation sheet based on which the final results were declared. My lord, here the allegation is against APSC, my lord. They say that in the charge sheet, my lord, against me, in the my lord, statement of allegations of the departmental proceeding charge sheet, that my marks were increased not by me, but I'm a beneficiary. My lord, this is the ground of my apprehension, my lord, that I may also be arrested, though I have not received summons as yet, my lord. But
no, but you see, the problem is that this has taken such a huge proportion that the interrogation is required. Otherwise,
my lord, everything has been seized, my lord. It is in the custody of the police, my lord. No further interrogation, no further evidence is required to be collected. Only interrogation. But I'll cooperate, my lord. My statements may be recorded. My lord, here, my lord, they paint me as a beneficiary of this anomalies.
no, you see, Mr. Nair, the second point is that once a charge sheet is submitted, you are to subject yourself to the jurisdiction of that court.
Yes, ma'am. But I am not an accused in the charge sheet. And they are arresting people who are not, my lord, named in the charge
It
sheet.
says that you are in charge sheet is submitted against you. No.
No. There nothing is stated, my lordship. Only charge sheet has been submitted, it is only stated.
No, I understand, but if there is a charge sheet against him, then we understand. Otherwise, we'll have to retain jurisdiction over the citizen. If he is an accused in the charge sheet, then I can understand. Can you get information by 2 o'clock? Just ask them. Because if he's if charge sheet has been submitted against you, then perhaps we'll have to close it and then. Because then you'll have to disclose about the charge sheet and then perhaps take up plea. At 2 o'clock, let him get the information.
Deeply obliged.
Item 5.
Item 5.
Yes, Mr. Chaudhary.
Letter has come for admission, my lord.
Yes.
My lord, the sole opposite party having died on 1st of October.
Oh, is it?
I filed a petition for substitution.
Yes.
under 22
It has come.
24.
It
And
has.
that petition, my lord, numbered as 3382 of 2023.
Yes.
That has already been disposed of, and this honorable court was pleased to come to a decision that since the petition was filed within time, my lord, court was pleased to direct impleadment.
Okay.
My lord, my humble prayer before lordship today, that the office also has given a note that they have impleaded by computers in this computer software. But my duty will be to implead those substituted heirs, my lord, in the cause title of the
Correct,
petition.
correct.
And so the matter is
Okay.
very urgent, my lord. I pray for time to list it immediately on.
No, that has already been done. That has already been done.
That's
Everything
done.
has been done.
That has been done by the office, my registry, my
So you
lord.
take steps now.
Then, my lord, now the lawyer concerned, my lord.
No, you'll have to take steps. Substituted, he
I'll
may
have
not
to
appear.
take steps, my
Yes,
lord. I will have to send, notice will go to them,
yes,
my lord.
notice has to go. Heard Mrs. V. Chaudhary, counsel for the petitioner. It is noted that on the death of the respondent, his 4 legal representatives have already been implemented pursuant to orders of this court passed, order dated 8/12/2023 passed by this court in IS Civil 3382 of 2023. Next paragraph. The petitioner shall take steps within 2 days, in course, today we'll have to take in course of the day today. In course of the day today for service of notice on the substituted respondents by registered post with AD. Next para. The postal receipt postal track report. In the above, you write issue notice returnable on. You want a shorter date. You want a shorter date. But you have to take steps today only. Returnable on 28/1/2024. Next list on 28/1/2024. Take steps today. We'll continue at 2. I may be 5 minutes late today.
In the morning, Lordship asked us to fix a date by consensus. So far, item 25 is concerned.
Just give it to the court master. We'll incorporate.
Wait.
Just tell them.
I don't know, although I am not there, Mr. Islam, he is there, he is suffering, he is not coming to the court. Someone brings the court by order, I don't know, probably by the claimant. My request on here would be, Mr. Islam, let it be after vacation.
What is here? Okay, we'll adjourn it. We'll take up when I take it up, I'll adjourn it. I need to know. Mr. Islam is unwell.
He is coming back from treatment. He will be available in the next month after vacation.
Oh, okay. Because I was not aware of his illness. That's why I'm asking. Because I know him since long, before joining in practice, I have been knowing him. His family is known to me otherwise. $36.
I take an instruction, madam, is ready to pay the invoice amount to Matrix fertilizers and somebody. But may I pay one thing, madam? Yes, given me telephoning instruction, madam. Then he submit an affidavit, if Lordship permits, madam, because I will submit.
No, that is okay, but since this is a anticipated bail application, the city is here. What we'll do is we grant you an interim bail and then ask you to deposit. We extend it, but with that condition.
On instruction, I had submitted.
It's okay. I don't disbelieve you.
I disbelieve my client. I'll be in trouble. That's about that.
There are certain things we must be very conscious. I appreciate what you said, but within ourselves we know it, but online. It takes away some of our freedom. And a lot of it, especially in my court, where I try to be frank with the learned counsel. I speak out my mind. I make certain comments which are which may not be taken in a very good, what do you call, in a good spirit. But still, it's my inherent habit to do it. Because I can't be very serious. So that is my drawback. And at times I also do this, what you call, the name I have given to myself is that Gaungura justice. Uh, Heard Mr. S.R. Abdullah, learned counsel for the petitioner, as well as Mr. K.K. Das, learned APP for the state. The learned, pursuant to the orders of this court, the learned APP has produced the case diary. Full stop. On a perusal of the same, it appears that there are materials against the petitioner of having custody of goods which are not consigned to him. Full stop. On a query of the court, the learned counsel for the petitioner has submitted that he will take necessary instructions as to whether the petitioner shall be ready and willing to either return the goods or to pay the value thereof. Full stop. On the said submission made by the learned counsel for the petitioner, the court is inclined to extend the interim bail to the petitioner, right? Order dated 21/7/2023 till the next returnable date. Full stop. In the meanwhile, the learned APP is at liberty to read the essential part of the case diary by making photocopies thereof for the perusal of the court, and the case diary can be sent back for updation. Full stop. List on how much time? After view, okay. This one, 19/1/2024.
Apply.
Item 37. Item 37.
Who is there in 37? A.K. Bora. What is there?
Lordship, it is dear Lordship. Dear Lordship. He has taken money, he is on the duty of Lordship to collect the loan amount, EMI. And he has misappropriated it, Lordship. One witness statement is also there. 3 lakhs. Three lakh 65,000.
Has he appeared before the IO?
Lordship. Statement I have not found. Lordship. I have not found the statement.
You're not there? Okay, none appears on call for the petitioner. So how are Mr. K.K. Das, and the APP has produced the case diary. And he has submitted that he has not found any entry in the case diary reflecting that the petitioner, namely Prabal Bora, on being granted interim clearance bail by order dated 18/10/2023, had appeared before the IO and cooperate with the investigation.
He has appeared, I have seen now, Lordship, but he further called for my lord. He has further asked to appear before.
Further asked to appear. But he appeared, and what did the IO do then?
He has a recorded his statement also, Lordship.
He has recorded the statement.
Not recorded.
But this is something which is, which you only read. You see, because if a person appears, the IO will not record it and then call him again and again.
But otherwise, Lordship, materials are there.
But that leads me to think that first he will remember, okay, what is your name? Then he will forget everything, and then next day we'll ask, oh, I forgot to ask you, what is your father's name? He'll say father's name. Oh, I am sorry, third day, please come on third day. I have to ask another question, where do you live? And then this questioning will go on and go on. In the uniform, how many pockets do the policemen have? Because you see, I was thinking that only lawyers are the God-sent professionals who have 11 pockets when they appear before the High Court. In the court there are 5, trousers there are 4, and then one in the shirt, that makes it 10. And when in High Court you appear, you also wear a gown, so you also have a bag. So there are 11 pockets which a lawyer has. Very, very, what you call, very favored profession by the God. Now, the question I'm asking is that with that sort of questioning by the IO, how many pockets do the police personnel have in their uniform? Don't say that. For instance, Justice Matteson has adjourned today. Full stop. The interim bail past release stands extended to the next date of listing. The case diary. This is from which place?
From Narayanpur.
Narayanpur. Okay, the case diary is written till the next date of listing. List from 3/1/2024. Okay. Your name? Ms. D. Parak, Counsel for the informant is present. No, I don't know. Please repeat again what you are saying. We'll consider when they are there. 42. Yes.
Lordship, I'm going for a short letter, Lordship, to call for a report regarding his involvement in the incident matter, Lordship.
We grant him an interim till next date.
Without the materials which have been collected so far of what, Lordship, whatever testimony, Lordship, because this is I did not explain the magnitude of the offenses, Lordship.
No, that is okay. But you see, if, the question is that if he's not a charge sheeted accused.
Lordship. Because I can explain, Lordship, a little bit, Lordship. Lordship, when the matter was charge sheeted, Lordship, after that, when the one-man commission was formed, Lordship, according to that report, Lordship, some anomalies were found, Lordship. To say some will be an understatement, Lordship, but in any case, Lordship, those materials are not before your Lordship, and I am also in darkness, Lordship, whether what are the involvement of the petitionary counsel, Lordship. And in view of that, Lordship, subsequently investigation is.
No, you see, there's a difficult situation. When it comes to a service personnel, you have charge sheeted him. Sorry, he's been in the disciplinary proceedings. He has been served with a notice, and therefore he has to attend the disciplinary proceeding. Correct. Now, if he can't appear there, that proceeding goes ex parte. Now, if he goes and appears there, he is arrested and brought to the police custody. So therefore, he's being prosecuted not only by the investigation agency, but also by by his own department, where his department facing a departmental proceeding. So therefore, we'll have to draw a parallel somewhere, because if he doesn't appear there, if he's made to abscond, then he can't appear in that proceedings.
View of that observation, Lordship, that only in view because he has to appear before the disciplinary authority, interim has been granted and it will be subject to further.
Yes, yes,
Lordship.
we'll do
If
that.
is
We'll
observed,
do that.
Lordship,
We'll do that. We'll say that it doesn't create a right to him.
Yes.
We'll protect you for that. But Mr. P.D. Nair, learned counsel for the petitioner, as well as Mr. B. Sharma, learned APP for the state. The petitioner is apprehending arrest in connection with Dibrugarh PS page 1 has prayed for his bail under section 438 CRPC. Stop. The case of the petitioner is that on the allegation that he had been appointed as a assistant registrar of cooperative societies in scam tainted APSC selection process, comma, and FIR dated. Where is that?
Page 15, my lord.
15.
Dated 27/10/2016.
27/10/2016 has been filed against unknown persons, comma, which has been investigated by the police. Next, the learned counsel for the petitioner has submitted that although the name of the petitioner does not appear in the charge sheet submitted in the matter, but the investigation are still being carried out, and there is apprehension that the petitioner may be arrested. So he has submitted that on his appointment being found questionable, a prima facie found questionable, comma, a charge sheet, departmental charge sheet. 38.
30 November.
30. The departmental proceeding has been drawn up. Disciplinary proceeding has been drawn up against the petitioner by the Principal Secretary to the Government of Assam Corporation Department, requiring him to show cause. So they submitted that his apprehending arrest, the apprehension is expressed that once he appears before the departmental in the departmental proceeding, comma, he may be arrested and he may be arrested. Next para. The learned APP has submitted that the APSC scam is of enormous proportion, where many candidates have been found to have been to have cleared the APSC examination through various dubious means, and as the investigation is unearthing several more incidents of such dubious appointments. I praise that some time be given to him to obtain the case diary and to ascertain the position of the petitioner. Next para. The court finds force in the submission made by the learned counsel, learned APP for the state. Stop. Nonetheless, having noted that as per the projection made by the petitioner that in the charge sheet submitted in connection with Dibrugarh PS case number 936 of 2016, he is not the named accused. The court also takes notice of the court, by taking notice of the pending departmental proceeding against the petitioner, is of the view that in the event the petitioner is unable to participate in the departmental proceedings, he would suffer more prejudice. So therefore, as an interim measure until the next date of listing, the court is inclined to grant interim pre-arrest bail to the petitioner, namely so-and-so, in connection with so-and-so, by providing that in the event of his arrest in connection with the aforementioned case, he shall be released on furnishing a bail bond of rupees 50,000 with true surety of like amount to the satisfaction of the arresting officer. The interim bail is granted to the on the following conditions. Appear before whom he should appear? SIT. He is an SIT. Before the SIT. Where is that? Just tell us, we'll modify the order. For the time being, because he'll not know, he'll not get a notice. Just on.
The forwarding report submitted for the other accused, sent by the Joint Commissioner of Police in charge.
Before the IO.
Listing also on the appearance.
Before the IO. I have the case. Next para. Having noted that the APS is that this may be a case which is a part of what is commonly known as APSC scam. The court is inclined to provide that the interim bail has been granted only taking note of the departmental proceeding against the petitioner, and therefore this interim bail would not create any right in favor of the petitioner for extension of the interim bail, which shall be considered in its own merit. Stop. List on when 8/1/2024 for production of case diary and obligor status report of investigation insofar as the insofar it concerns the petitioner herein. No, these are not very happy. It's just the pre-Christmas mood. Yes, item on production.
Production list item 1.
EB number 4350.
Oh, this is the same matter.
Against the FIR file is low issue, my lord. But the petitioners of the same.
We'll grant an interim, let him appear before the, will appear before the IO within 10 days from today. Mr. Alam, let me tell you something. Because in the application, it's there. In the earlier petition, in the earlier objection also, it was there. You see, we may take a very adverse opinion about the pleadings made, because even in that matter and this matter, you may take an adverse adverse note of the pleadings. You see, you have highlighted a portion that the petitioner is the has a sister who is attached to you. Correct. That means it's a subvert way of influencing the court. Why you want to make a lawyer who's a junior in your chamber as a material exhibit? Why would you do it? No, that's why I'm saying. Because it's not that even if it's a bail matter that I don't read. The objection which you have filed, it's not that we have not read. Therefore, when we are making a statement identifying the accused with a lawyer in your chamber, it is outrightly an attempt to influence the court. And if I take that view, we dismiss your bail application in limine. Correct. So you amend it. First off, in the next para. No. Whatever has happened, you see, you are identifying not only that, you are also saying that something has been captured in the mobile of your junior and that can be shown to the court. You see, those things, we take it very seriously. Because what you call, you just can't imagine what goes on in our mind. I'm just interacting with you, it's just to tell you that the practice adopted is not a fair practice. If you make your junior as a exhibit in court, then we'll take a different way. Because this pen is something which is within my control. I'm just telling you, we take an exception to it because this is a pen which works under my control. So if we see any attempt to influence the court, because even day before yesterday, we took an exception to that. At 2 o'clock, I gave a lecture for half an hour. Just in view of the proceedings which came before us on that day. So I'm just telling you. No, do not that. You just amend it, you have it struck off. Those things, because we take an exception to this. No, it has to go before the section and it's been done, not before the court. Say the outset, the learned Mr. N. Alam in counsel for the petitioner seeks leave of the court to strike out certain portion of the statement made in this application. If prayer is allowed, the corrections may be done in the presence of AOJ, bail, what is that, criminal? That's the key section, bail is criminal appeal section. Next para, by this application under section 438 CRPC, the petitioners who are apprehending arrest in connection with Gauripur PS case number 467 of 2023 under section 380 IPC is as paid for prior as bail. Let the case diary be produced on so and so. Next para.
22nd January.
22nd January 2023. Next para. Having regard to the nature of the allegations in the FIR and considering the stand taken by the petitioners regarding a cross case being dispute PS case number. What is that?
22141.
2214 of 2023. Under section 448, 354, 325, 365 of 34 IPC. The court is inclined to grant interim prior as bail to the petitioners, namely so and so. By providing that in the event of arrest of the petitioners, so and so, bail bond of rupees 25,000 each with one security of like amount to the satisfaction of the arresting officer. Bail is granted on the following conditions. One, within 10 days, 10 days from today.
Time being item 3.
Yes, Mr. Rai.
During the limited time, I tried to find whether there is any specific order of the Honorable Supreme Court in this regard, but I could not find it in regard whether any interim order can be passed. But while discussing with my colleague, Mr. Anenja, he just told me that in the order passed by this Honorable, in a similar application under Article 227, an interim order was passed.
No, we are passing it. That's why we are asking this question. Will it be proper? Just pass it on.
One order I came across, Your Lordship, of the Delhi High Court, with regard to 227, wherein the issue with regard to that interim, whether interim order can be passed or not under 227, it was held that it could not be passed. That order, after going through, I have gone through it. But that order, Your Lordship, that arises out of an application wherein the injunction application was rejected.
Where's the interim order here?
The page 77 of the.
77. The page you are showing me is page 70.
77.
No. The earlier order you showed me is page 70. That deposition of DW1.
That is in IA.
That is in IA.
IA page 46 and Annexure 6.
Same thing, it is page 70 here also. Is
Yes,
it not?
yes, I have also annexed it.
Is it page 70? Just tell us.
Yes, sir.
And the order is at page 77.
Yes, in order.
Okay, let me go through it. I'll pass orders. I've not yet made up my mind. In the afternoon, we had a meeting. I had to leave.
We improve both the orders, Your Lordship, at page 78 also.
78 also.
Because the injunction application was kept in abeyance.
What is this Mijje case number 352?
That is the condonation application.
Where is that? Which page?
The condonation application.
Yes.
That is it, not page 61, annexure 5.
61.
Yes. Here in this case, your lordship, we applied for the copy within time. If your lordship peruses the page 13.
No, whatever be the reason, because that reason we are not going to touch upon, because that is the jurisdiction of the trial court. Let me go through it. I have not yet could not make up my mind. If I did not get time.
The problem arises the police. They say that your suit is dismissed, now you should leave the court. The problem arises, they didn't file the counter.
Okay. Okay, let me examine it. I couldn't make my mind. Yeah, afternoon.
April.
December হৈ যাব ন item 37 next date to 3-1 sir reopening 5-1 দিব পাৰি নেকি sir তেনেহলে এই দিন দুদিন পিছত এটা item 7
Okay. Who was for the petitioner? Who was for the petitioner?
here one sir appear one
Oh, okay. Okay. Because other side had to be informed, that is why. Okay, okay. Item 7. Yes. Quantum. You can deposit 50%. Okay. You withdraw it. Okay.
Claimant number 1.
Claimant number 1. Who is claimant number 1? But why not number 2?
And 3 are minor, but 2 has become major.
Huh?
2 also has become major, so they are the daughters.
No, this 1 and 2 are daughters.
Yes.
So
No, one is the wife, 2 and 3 are daughters.
the 2 is the son.
2 is the son.
2 is the son.
3 is the sons.
2 is the son.
Yes.
So number 3, some amount will go in fixed deposit. For 3, benefit of 3, it will go to fixed deposit.
Yes, sir. That is
Okay.
1 lakh mechanical. For others, mechanical release.
Oh, okay. 50% is 7.5 lakh.
7.5.
7.5 lakh. No, not 1 lakh. We'll have it equal. This SY counts for the appellant, Mr. A. Agarwal, and counts for the respondent numbers 1, 2, and 3. MC appeal, admit notice, steps within 2 days for service of notice on. And 2 working days could be 2 working days for service of notice on respondent numbers 4 and 5 by registered post with ED. Notice returnable on which date? After 6 weeks, returnable date? 12/12. And IA? Stay subject to deposit of 50%. You want to give it to her? Take it from her. Subject to deposit of 50% of the awarded sum for the registry of this court. First off, on such deposit being made within a period of 6 weeks, on such deposit being made, registry will permit the opposite parties number 1, 2, and 3 to receive the deposited amount equally. Full stop. Taking note of the fact that the opposite party number 3 is a minor, comma, his share of the money shall be kept in fixed deposit account by breaking it up into 5 fixed deposits. For such term as may be permitted by the bank or for a period till he attains majority. Just insofar as the respondent numbers 1 and opposite parties number 1 and 2 is concerned, comma, while the registry shall permit them to withdraw 50% through their bank account, comma, balance 50% of their respective shares shall be converted into fixed deposits in 2 fixed deposits. 2 to 3, 2 to 3 fixed deposits in their name for a period of for a period of 3 years or and this introductory application stands allowed and disposed of. 50% amount will be fixed deposit, 50% you will get through bank. And for the child, third child, entire money in the fixed deposit. Give it discharge. Okay. Item 8.
Item 8.
On the both sides are represented. On behalf of Mr. T. Islam, counsel for the appellant, it is submitted that he is unwell and therefore on his prayer, on prayer being made, comma, the matter stands adjourned today. List. On 22/1/2024. The office note dated 18/12/2023 reflects that notice is duly served on respondent number 9 and ID card has been received back. Next, the learned counsel for the appellant shall also take note that in respect of notice on respondent number 3, comma, the same has been returned back with postal remark, inverted commas, addressee died, inverted comma close, full stop. Therefore, the learned counsel for the applicant will take note and take note of the same and take appropriate steps. So be that as it may, as the learned counsel for the petitioner is unwell and is not present, list the matter on 22. 20?
22/1.
22/1. Okay. 49. Oh, sorry, this is 49.
Only 9.
Only 9. Okay.
Lordship, as per office note 19/12/23, respondent 1-2 has filed wakalatnama.
Yes.
3-4 neither
Not been
ID
received
card
back.
and LCR.
It was sent on 5. You have to take first steps, I think. Last.
That's my note, I have 5-1I. That will be taken up on 3776 of 23.
Yes, what is that?
But this is for withdrawal of 50% deposited by the insurance company already.
You can allow this,
Yes, but
you can allow this application.
yes, but the amount is deposited in the tribunal. So
Yes.
his another prayer is that the LCR may be sent.
Sent to the
And lordship,
MSCD for
our-
a limited.
Oh,
period.
acha.
They can
Right, right.
withdraw lordship provided they give a bond for the time being. Because our contention is that the other vehicle in which the deceased was traveling, rash and negligence was reduced everything. So bond, if we win, then okay, otherwise also they do not lose.
Oh, what is his status?
Lordship, this is the year the notices were sent.
No, his status is what? He is doing what?
He was a mason.
Mason. So no point taking a bond from a mason.
No, his wife is.
That is his
Yeah,
mother and
Wife and.
the
No, I
deceased was
understand,
mason.
but you see, we are concerned with the status. If he is a mason,
No, we are,
how is mother and the deceased a mason? How is wife and
Not wife, mother
Mother and
and
father.
father.
mother and father? How will they return the money? Assuming that you win, if you want a recovery from them, with that state of society,
Okay.
with that state of society, Mr. A. Bhattacharya, the counsel for the applicant, and Ms. R.D. Mazumdar, learned counsel for the opposite party number 1. Next, by filing this interrogatory application, the applicant has brought to the notice of the court that the 50% of the awarded amount has been deposited by the opposite party number 1 before the Court of Learned, MSCT number 3, Kamrup Metro, Guwahati. And therefore, it is expressed by the learned counsel for the applicant that they intend to move the said learned tribunal for permitting them to withdraw the money. And for such purpose, it is submitted that the LCR, which has been called for, be temporarily sent back to the court of to the learned member, MSCT number 3, Kamrup Metro, Guwahati, for passing appropriate orders and to return back the record to this court.
Lordship may stipulate a time.
Right.
So
That's
that
okay. Taking note of the same. The court is inclined to allow this application. With the following orders. Number 1, the applicant is permitted to move the learned MSCT number 3, Kamrup Metro, Guwahati, for release of the money. Number 2, the registry shall send back the LCR of the said MSC case number 65 of 2018 to the back to the said learned tribunal, the learned tribunal on passing appropriate orders, shall return back the LCR to this court. Third, the respondent number, the opposite party number 1, is also permitted to participate in the proceedings before MSCT.
is not
Uh,
necessary. That is
We just give you liberty, you do whatever you want. Participate in the proceedings of.
disposed of. We cannot say anything because the case is disposed of.
No, we are allowing him to file an application for withdrawal. We are not passing any orders here. We are not passing any orders here. We have to pass it in proceedings of MSC case number 65 of 2018, within bracket disposed of. In the matter of prayer, proposed prayer by the applicant for withdrawal of money.
My lord, if that is being ordered like this, my lord, they will again send notice to insurance company. That will take some time.
No, he'll appear, she'll appear. You can just tell her.
the advocate who was appearing, I'll tell them, inform. I'll
You
send
just
this to
inform
all
them.
of them.
The council, no, not the council representing Oriental Insurance Company Limited, passive rate.
One
And notice need not be sent to the opposite party, and the notice and it would suffice if the learned counsel for the applicant serves a notice on the prior notice of this of the application to the learned counsel on record for the Oriental Insurance Company Limited, and based on that, it would be permissible for the learned MACT number 3, Kamrumet of Guwahati, to proceed with the matter.
One.
Yes,
In the appeal, Lordship may kindly see page number 25.
25. Yes,
That is part of the judgment passed by the tribunal. Page 25.
25. Yes,
That is the award portion.
yes,
Total award is 10,01,200. Out of that, para 34,
yes,
561,200 shall be released to the claimant so and so, mother of the deceased, to meet the immediate exigencies. Then 40,000 filial consortium to the father of the deceased, and the rest of the 4 lakh, 2 fixed deposit amounting to 2 lakh each in the
Yes.
name for 5 years. If had this order been passed for deposit of money in the High Court, what is the system followed by the registry? They set apart this 4 lakh rupees. Then out of that 6 lakh, they will give the 50%. Then it will come down to 3 lakh only. So if this embargo does not come in the way of my getting a 5 lakh rupees at least out of this 10 lakh, then I'll be benefited by these people are.
no, I don't know. It is 10 lakh according to me. You see, it says 2 fixed deposit of 2 lakh.
Yes.
That means 4 lakh.
4 lakh for 5 years.
4 lakh for 5 years. No, that tenure you forget for a time being. Now we are on the money. 4 lakh is gone. 561 is to be released and less 40% to the 40,000 to the father. So it amounts to 10 lakh rupees.
10 lakh
Your
rupees, but in the meantime, if 50% is directed to be released during the interim of this appeal, what registry do in our case, that 4 lakh they will keep aside, and out of that 6 lakh they will divide it into 50%, and they will give us only that portion of 50% of 6 lakh, not the 50% of 10 lakh.
no, you see, but that requires a modification of the order. Please try to understand. The registry is not wrong.
Yeah.
You see, the tribunal has ordered that 2 lakh rupees can be kept in fixed deposit.
Yes.
So therefore, that becomes untouchable.
Yes.
So what remains is the only, we only have jurisdiction over 5,61,000. Or otherwise, if the order is modified, this order has to be modified that 2 lakh rupees should not be the fixed deposit. It should be reduced to a particular quantum. Till then, this order has to be complied with, because you see the direction to keep money in fixed deposit emanated from the Delhi High Court judgment, which the Supreme Court has adopted and says that that is the law.
What my prayer is, the 50% direct of this award will not cross that this fixed deposit part. Therefore, since they have already deposited 50%, so this is more than 5 lakh million. At least 5 lakh should be.
No, you move that court. We are not saying anything.
Then only
You see, we are since that amount has been deposited before that court.
because the direction was such from the High Court.
Huh?
The direction from the High Court.
Where is that?
Lordship, in
That
this
is in my
petition
eye.
itself, page 10, Lordship.
Page?
His I, Lordship. Page 10.
I open
Uh,
page.
The appeal is admitted subject to deposit of 50% of the awarded amount before the learned member MSCT comes in connection with.
So then make condition number 4, that as this court has permitted the applicant to move the to move the learned member, MSCT number 3, Kamrup Metro Guwahati, for release of the amount, comma, it would be open to the said learned tribunal to pass appropriate orders, notwithstanding that the appeal. Oh, no, I don't think that would be appropriate. I do the releasing order. Let them withdraw it from there. Because since this order 10 is by this court, we take the responsibility.
Lordship,
Since the order is by our court, we take the responsibility of ordering a release.
Yes.
Okay. Let me cut it. Application for so and so. It is the amount of this 50% the amount deposited pursuant to order dated 7/12/2022 passed by this court in this appeal.
the date is in the appeal 7/12/20.
Oh, no, I was wrongly perceiving it because of the fact that there is no IA here.
I have filed I.
No. Your IA is not there.
No, it was because the EA was filed.
No, that's why. You see, order is not here. I am presupposing that it is passed by the tribunal.
This court, because the court at that time felt that.
No, it's okay, but I thought that since the IA is normally there with an appeal, I thought that this order was passed by the tribunal. And that's why I took that view.
No, somehow because we missed filing the IA, then while admitting, they were not.
No, that's okay. That's okay. We are not going to there. Next para. The learned counsel for the opposite party, Oriental Insurance Company Limited, has submitted, sorry, the name Ms. Majumdar, has submitted that pursuant to the said order, 50% of the awarded sum has been deposited before the MSCT number 3, Kamrup Metro Guwahati. Next para. Accordingly, the learned counsel for the applicant submits that the LCR is required to be sent back, and only on receipt of the LCR, the tribunal would be able to release the deposited amount before to the applicants. Next para. Not next para, continue. It is also submitted that as per the award passed, amount of rupees 2 lakh each is required to be deposited in the name of claimant number 1. 2 fixed deposit of 2 lakh each for a period for a period of 5 years. Most likely we submitted that. If the said amount is retained in if out of rupees 5,61,200, the applicant can only receive rupees 1,61,200. Which is, and it is submitted that the said amount would be meager. Correct?
I will get only 50% of 561,200.
No, you will get 50% of 10,01,200. Demand deposit is
50% is second, but the problem is the fixed amount.
That is what I am saying. If 4 lakh is retained, then only 1 lakh rupees you get, 161. That's what I am saying.
They said that they have deposited 50%. That is the information I have.
50% delay.
50% is 561.
You have left 1,01,000.
1,61,200 you will be getting. So it will be too meager. Because out of
50% of that.
no, because out of the said amount, rupees 40,000 is required to be released to the to the opposite, to the claimant number 2. No, to the opposite, to the respondent number 2, who is the father of the deceased. Next, taking note of the submissions made by the counsel for the petitioner, the court is inclined to direct to order release of the deposited amount as follows. Number 1, the learned member MSCT number 3, Kamru Metro Guwahati, shall, out of the deposited amount out of the 50% deposited amount, shall convert ₹1,00,000 each in 2 fixed deposit amount in the name of the claimant number to the applicant number 1. Full stop. Sum of which 20,000 shall be released in number 2. The sum of which 20,000 shall be released in favor of the opposite party number 2 in the claim petition, namely what is the name? Sarat Chandra Nath, father of the deceased.
He's also applicant.
No,
Like,
there are 2 applicants.
applicants, yes, both of them.
Then why in this order, page 25, it is written 40,000 to the OP number 2? What is this?
So only that amount is given to him
As
because
PDF
only
also
mother will be dependent. As per Sarla Verma, mother will be entitled.
Mother is
for-
Also, he'll be, no. You see, in the claim petition, he is a claimant.
Yes.
So why this is written as OP? It is typing mistake then.
Oh, yes.
Page 25
yes,
is a typing mistake.
Claimant number.
claimant.
No, to the claimant number 2, not opposite one. No, it's claimant number 2, namely so and so Sarat Chandra Datta, who is the father of the deceased. Full stop. 40. The remaining amount shall be released to the applicant number 1, namely Swarnalata Nath, Srimati Swarnalata Nath, into a bank account on being identified by her learned counsel and on providing of the bank particulars to the learned tribunal. Next para, to facilitate the release of the 50% amount deposited in favor of the claimants, public applicants, let the LCR be sent back to the learned member MSCT, Kamru Metro Guwahati,
Number 3.
Guwahati, to facilitate such payment, on such payment being made, the LCR shall be expeditiously returned back to this court in connection with MSC Appeal number 826 of 2022. Next, this application stands disposed of.
Should make it preferably within 1 month or 2 months because the LCR, otherwise the LCR won't again
No, it will come back.
come back.
It will come back. It will come
But
back.
fixed deposit for 5 years.
5 years.
5 years.
1 lakh
That
each.
may be
1 lakh each. We have already ordered.
public.
Hello. In the appeal lordship, so we have to await if lordship passes any order.
Okay, in appeal, say, counsel for the appellant and respondent numbers 1 and 2 are present. In respect of in respect of respondent numbers 3 and 4, the applicant shall take first steps within 2 working days for service of notice on the said respondents by registered post with AD. A postal decision number track report. List notice is returnable on 12/2/2024. List accordingly.
Item 10.
Yes. Yes.
Respondent number 1 to 4 and 7 already been appeared.
Where is the order? Impugn order page. Where is the order? Where is the impugn order?
Notice has not been completed.
Not yet been completed.
Only 1 to 4 and 7 he appeared.
Who has not appeared?
Respondent number 5, 6 and 8. Not yet appeared.
You are appearing for?
And appeal for the petitioner's one.
No. You are appearing for?
Respondent number 1 and
Pro forma respondent number 1 and 2. Who is for 1 to 4? You are for 1 to 4. Seven, you are there. Okay. The counsel for the petitioner, comma, respondent numbers 1 to 4, comma, respondent number 7 are present. No, not so 7, and perform respondent numbers 1 and 2 are present. In view of office note dated 20/12/2023, comma, the petitioner shall take first steps in course of the day for service of notice. Make it 2 working days for service of notice on the respondent numbers 5, 6, and 8. So the notice is made returnable on so and so. Next paragraph.
12/2.
With that statement that just listen to me. The postal receipt number and track report. That's paragraph. List on so and so. Okay.
List on 12. Item 12.
It's a standard statement. Petitioners, the council is permitted to collect the postal receipt number and submit postal tax per APL. Yes.
Elections, my lord, there is a delay of 410 days notice issued, my lord. But out of the same judgment, my lord, on the same day, one IA, my lord, already condoned, my lord. Delay and LA appeal also, my lord. LA appeal also not. For enhancement. Same day.
Yes, CKS Barwa is not there.
I am here.
No, CKS Barwa is for
Yes.
See, for NF Railway.
Copy is also along with him, madam. He informed me earlier.
Hmm?
Earlier occasion, he told me that copy is also, whenever case is listed, he will inform me. For me.
How many days delay?
But here, madam, here, this calculated as 410 days, madam.
410 days.
Yes.
Okay, this is right, Mr. S. Das, counsel for the applicant. Mr. T.G. Barwal and T.K. Barwal and T.K. Gogoi, and
T.R. Gogoi.
T.R. Gogoi, and government advocate
For respondent number.
for respondent number 3. And Mr. C.K. Barwal and CGC appearing for respondent numbers 1 and 2. Control the delay of how many days?
410 days, madam.
410 days. Connected. And 410 days.
LA appeal number.
The judgment dated?
LA reference case
June.
number 24 of the 30.
Reference case number 24 of 13.
30.
And order dated
Order dated, my lord, 21/12/19.
21/12. Okay, same order. No, only names will change, same order. And last,
LA
Ah.
yes.
same order. Just don't give that bold part, huh? It will be normal font, not bold.
Delay
This one.
Kundan disposal.
Disposal, same order.
Evaluation.
Item 13.
This for order, office for order, my lord. It is 8/5/23, madam. The opposite party, deposited amount, madam, 28 plus 28.
Yes, it can be released, Mrs. Agia.
See, I have made one rough calculation also. If all the grounds taken by us are accepted allowed by this honorable court, a compensation may come around 15 lakhs also. So up to 15 lakhs, Lordship, I have no difficulty. But one thing, Lordship, I have seen today from the LCR, none of the exhibits are signed, Lordship. LCR has come. But how judgment was pronounced, Lordship, I have seen for the first time.
Mr. Chan will take it up on fourth of January. The exhibits are not signed. Is right. Mr. R.S. Chauhan, counsel for the applicant, as well as Mr. A.J. Sekiel, and counsel for the opposite party number 1, and Mr. Correspondent number 4. ये फाइल में कराता ना okay, and Mr. S.H. Sikdar, Leonard, counsel for respondent number 4. To stop on a query of the court, comma, the learned counsel for the opposite party number 1 has submitted that on a rough calculation being made by him, comma, which is subject to correction, if all the grounds taken in the appeal is allowed, comma, he may not object to the withdrawal of this 15 lakh by the applicant. However, he has also pointed out that he has perused the LCR and he has found that none of the exhibits have been countersigned by the learned member, comma, MICT number 2, Kamru Metro Guwahati. Full stop. Accordingly, the passing of the order in this application stands deferred. Matter will be next in the meantime. Let this record be brought to the notice of the learned registrar within bracket judicial to examine to have this LCR examined. And if the exhibits do not bear the signature of the concerned officer, comma, the officer may be asked to countersign the exhibits. For which the officer concerned will have to bear their own cost of traveling. In the event, next paragraph, be there as it may, list on 5/1/2024. We have almost passed the order, but there is some revision to be done. This will be only an IA. In the main appeal, you write tag this matter when the corrected IA is listed on 5/1/2024. The service is complete in that.
Service only of respondent number 5 is has not come back. AD has not come back.
Then you also say, in the meanwhile, the matter will be put up before the Laozima court for passing appropriate orders as regards service or notice on respondent number 5. Okay.
Item 14.
For enhancement. Oh, okay. Just take the order. This is Mr. A.R. Agarwala, counsel for the applicant. Application for confirmation of delay. How much day?
44 days.
44 days beyond the period of limitation in filing the connected appeal. Notice steps within 2 working days. Notice is made returnable on 12/2/2024. List accordingly. Pardon me?
16 is also there.
I do not get it.
Item number 16 loads.
16 is also same.
Same.
How many days?
How many?
38 Lordship.
238. Okay, same order. Okay. Okay, 16. Okay. 15.
Yeah, please, Your Honor, this application is filed for the continuation of a delay in preferring the
এগুলা
appeal.
order মুন্না করে লই লব
Delay is
মুন্না
of
করে
a
লই
five.
লব এগুলা order মুন্না করে লই লব standard orders coordination of delay
Yes, Your Honor, the delay is of 544 days, Your Honor.
544. You'll have to explain the delay.
Yes, Your Honor.
You'll have to explain your delay because 544 days we are not sending notice unless we are satisfied.
Yes, Your Honor, because like what happened in preferring the appeal, Your Honor, we had applied for the certified copy as on 30/12/2021, Your Honor. Thereafter, the certified copy, it was received on 03/11/2021. And after that, the applicant, Your Honor, he suffered from a COVID-19, Your Honor, and as such, he was not able to contact us, Your Honor. And thereafter, again in the month of December 2022, he had handed over us the documents, but still, he had lost the contact with us, Your Honor. And somehow, on the last week of August 2023, Your Honor, he could contact us, and thereafter, we were able to file this
But
appeal.
you see, this is negligence. It can't be a ground for condoning because 500 days.
Yes, Your Honor. Yes, Your Honor, the notices might be issued, Your
No, it's, nothing is nothing is mechanical.
No, Your Honor.
500 days, you see, if we are not satisfied, why we should issue a notice? But this is negligence. It's not a case where
No, actually, the applicant, he was suffering from a COVID-19, Your Honor, and he was isolated.
your statement will not make it. Those things we find it very difficult to accept.
Only the
COVID, you
notices
see,
might be issued, Your Honor.
no. Nothing is mechanical. There will be mechanical issuance of notice without being satisfied as to the bona fides. You see, I suffered COVID twice, very severely. But look at the amount of what you call work which I have, what you call the amount of leave I have taken. Because if I have COVID for 14 days, they won't allow me to come in. Correct. But even in that COVID period, I have held what you call an urgent matter in the court I took from video conferencing. I attended the very urgent what you call meetings of the committees during that period. I'm not comparing someone with me. What I am saying is that you see, merely saying that he is a COVID would not be sufficient. There are no documents annexed here.
Yes, sir. The documents are not.
Uh,
Qualify prayer might be allowed.
I'll just adjourn it. You satisfy us. It can't be mechanical. Even in issuance of notice, I can't be a post office. Correct. This is something I won't do. Your name?
H. Goswami.
Mr. H. Goswami, counsel for the applicant. Comment from the evidence made in this interrogatory application. Court is not satisfied with the explanation tendered for the delay. So, next para, therefore, the learned counsel for the applicant pays for some time to take instructions and to file additional affidavit if required to supplement this application. Full stop. Matter stands adjourned today. List immediately after ensuing winter vacation. You file it in the meantime, you can supplement it.
Deeply obliged.
Item 17.
Application for combination of delay.
How much?
89 days. 89 days.
89, okay. Mrs. M. Chaudhary, for the applicant, delay of 89 days beyond the period of innovation. Notice steps within 2 working days. Notice made return on 12/2, list accordingly. Or list on said day, on 20/12/2022.
It's that as a usual.
This coordination, you take it only by registered post. Only registered post, and you can collect postal digit number and track report.
Item 19.
19.
If the IA score combination of.
How much days?
If there is a delay of 211 days.
What is the explanation?
If people with financial hardship and trauma. On time. The victim is not yet fully recovered from his trauma.
No, that cannot be a ground. You see, this 2018, 5 years now. One can't be in such a shock for 5 years. That won't be able to come. This was enhancement. You tell us when she got the when the claimants got the money.
There was, my lord, there are reasonable grounds for appeal, my lord.
No, that's okay. They may be very good grounds. But this judgment was on 9/2/2023. When did you come to tribunal and collected your payment? You take it straight because the 200-300 days for this MSD claim applications. Huh?
211 days. 211.
Because you see you understand the question. Once you say that you have received the money, financial hardship goes away. That's why we are asking you a question, when do you get the money? When you got the money, the financial hardship goes away. Then what is the explanation of delay?
If the victim was suffering from mental trauma.
No. You see, that can't be a reason. Mental trauma, you'll have to demonstrate for something more. You better supplement it on the next date. Because you have to give us the details. Nothing for granted. Your name? Mr. M.N. Zaman, General Counsel. M.M. Zaman, General Counsel for the applicant. As the court does not find the grounds for delay very convincing, the learned counsel for the applicant prays for some time to supplement this application with additional affidavit. Prayer is allowed. List after answering with defecation. 20.
Made the boss.
Yes.
The claimant is the appellant here, madam. Delay of 495 days.
Same thing.
Our claim, no, madam. Our claim petition was dismissed, not entertained.
But what is the ground of delay?
My lord, your losses. I have described all these in paragraph 2 to 4.
But what is the reason for delay?
Delay for my lord, initially the claim petition was dismissed, my lord, not question of maintenance. So they filed a review petition. The same fate also happened. Then because of this, there was a delay. I have annexed in a memo of appeal.
So the review was dismissed when? Review was dismissed when?
Review was dismissed. After review, there is very short date, my lord. Review was dismissed. I have annexed.
Just tell me the date.
I'm giving the date, man. Review was dismissed. Review was dismissed by judgment dated 23/5/2023.
23/5/23.
Yes.
Okay. M.H. Babu here, counsel for the applicant. Application number 5 of the Limitation Act, read with section 14 of the said act. Next, the learned counsel for the applicant has submitted that the claim petition of the applicant was dismissed on 9/3/2022, and thereafter the applicant preferred a review application, which was disposed of by order dated 23/5/2023, and therefore, and by the time this appeal was filed, there has been an inadvertent delay of how many days?
495 days.
495 days beyond the period of limitation in filing the connected appeal. The issue notice steps within 2 working days. A notice may return about 12/2. The postal receipt and track report list on 12/2/2023.
Much obliged.
21.
Item 21.
Yes, Mr. Zawan.
494 days.
Again, the same thing.
Yes, Lordship. But I have no instruction at what time, whether they have withdrawn the award.
You
or
take
not.
instructions, you supplement it. You see, even 400 days we are doing it. We have to be satisfied because even in condonation, I don't issue a what you call notice mechanically unless being satisfied. The same order, Mr. Zaman. He supplement this application with an additional affidavit. This item 21. Okay. 22,
22, Lordship, there is a delay of 208 days.
210. What is the explanation here?
Same explanation as earlier, madam.
Same thing. Okay, same. Supplemented because there must be something convincing. Same order here, 22.
This victim is also not yet fully recovered.
Huh?
As on date, he is not fully
Where
recovered.
is that statement?
Lordship, paragraph number 3, ma'am.
Paragraph 3.
Paragraph 3, page number 4, ma'am.
Just a moment.
The applicant has been going through great financial hardship and mental trauma.
Just a moment. Just a moment.
Yes.
Okay. Mr. M. Zaman, counsel for the applicant. Application under Section 5 of the Limitation Act for condonation of delay of 210 days beyond the period of limitation in filing the appeal. Notice steps within 2 working days. The postal receipt number and track report. List from 12 to 2023. And Mr. Zaman, you see, you are all young people. You should spend more time reading books because your application is otherwise defective. You know why? Unless you read the MSCT Act before coming to court, you will not understand. In a limitation, in the Limitation Act, there is a provision which is called Section 29. You read Section 29, read Section 173, second proviso, then you will understand. Your application could have been dismissed in limine. Read those 2 sections, and next time when you are in this court, if I am taking up MSCT matters, 10:30 on that day, 10:15 on that day, before we begin with the matters, you tell us, what did you understand? Correct?
Yeah, or item 21, I don't notice over there.
Aye, it would adjourn all. It will adjourn. Yes, item 23. Yes, but there is a legal issue. There is a legal issue here. If one brother cannot take it, should the second brother take it?
As per the roster, I think it is come.
No, I don't know. I'm just asking a legal question. Because it is the entire family who can't take it up then. No.
They are related to go to some other court.
Yes. Now, yes, WPC 6116. Yes, what has happened, Mr. Sharma? Why it has come here?
My lord, I have filed one IA, my lord, for my lord, modification of order of this honorable court, my lord.
For?
Modification on clarification, my lord. because
Modification of the order. Just a moment.
Page 26 of my
Just
IA, my
a
lord.
moment. Just a moment.
Yes. Page 26 is the operative portion of my.
Page?
26 of my IA. my lord.
26. Yes.
Paragraph number 6, my lord.
Para 6.
Supporting the similar as reported to
Yes.
OM bearing.
How is it troubling you?
My lord, the honorable court, my lord, provided that the NRL authorities, while processing the my lord, visa running bill, my lord, strictly adhered to the my lord,
Memorandum. Yes.
My lord, now, my lord, the responding NRL authorities have, my lord, filed the affidavit, my lord. And my lord, in the meantime, my lord, the NRL authorities asked me to, my lord, produce the, my lord, submit the originals of the vouchers and TP salas, my lord. In this case, my lord, I am, my lord, that procuring the, my lord, ready mixed concrete, my lord, from the suppliers who use and, my lord, the forest producers, and they have already paid the forest royalty to the, my lord, concerned.
No, you see, that is an order. We have also followed the order. This is order of this court that the forest
Yes.
would have a right to follow that trail.
My lord, now, my lord, my lord, today, my lord, I am limited prayer, my lord, that the respondents have filed affidavit, my lord. They have stated that 2% is, my lord, on the cost of the, my lord, total cost of the project, my lord. So my humble prayer before this honorable court, my lord, the NRL authorities may process the, my lord, my running bill, holding, my lord, or deducting 2% of the, my lord, that only, my lord.
Yes.
Only there. Otherwise, my lord, I
Issue here is with regard to payment of forest rent. There is a notification of 2021 by which the concession rules have been amended, madam. Now the requirement is that you have to pay the forest royalty on the total project cost. So the forest authorities have also directed us that if they do not pay, we have to deduct. But it is actually not our primary duty to deduct. It is their duty primarily to pay the forest royalty, produce the forest royalty clearance certificate, and we process the bills. Now they are not doing it, and compulsorily we are having to deduct money. It is an added responsibility on us. Now we are deducting from each and every contractor, and we are having to remit to the forest authority. So if there is no other, Lordship may observe that there is no other impediment in processing his bills, we may deduct the forest royalty and
2%,
whatever is the forest applicable. Lordship will not say 2% because there are some other added things, like income tax, GST, everything. So it is not exactly 2%, it's slightly more than 2%. So whatever is the admissible amount of forest royalty, Lordship may give us the liberty to deduct.
Yes, ma'am.
And if there is no other impediment, then it may be processed.
Okay.
Excluding GST.
Heard Mr. R. Sharma and counsel for the applicant, as well as Mr. N. Dekal, counsel for the
NRL, madam. Respondents.
NRL, respondent numbers 4 to 9.
Because the notification may not relied upon by my learned friend on the basis of which the order was passed, madam. That is not applicable. That is why he is having difficulty.
Yes.
Just a moment.
But my lord, could not, my lord, collect the, my lord, originals of the, my lord, vouchers and, my lord, all this.
But this forest, nobody is there.
Ultimately, it is the royalty of the forest.
My lord, they can process, my lord, at least, my lord, otherwise.
No.
That is not
Just
coming, my lord.
none appears on call for the opposite party numbers
1 to 3.
1, 2, and 3. Next para. This interlocutory application has been filed by the applicant, who is the writ petitioner, in WBC 6116 of 2023 with a prayer to modify the order of this court dated
1610.
15/10/2023, 16/10/2023, passed in WBC 6116 of 2023, by permitting the opposite party numbers 4 to 9 to process the bills of the applicants if there is no other impediment, and release the contractual dues by deducting the by deducting the taxes and other levies due to the forest department and or other authorities. Correct?
The order doesn't say so, Madam.
No, not I'm saying. He's saying that modification.
He's seeking that one.
Correct.
Right.
My sentence are right.
Yes.
Next para. In connection with the prayer made, the learned counsel for the opposite parties number 4 to 9 has submitted that under the what is that? Assam minor.
Assam Minor Mineral Concession Rules.
This is right there.
2013.
2013, as amended.
By the
It is-
Assam Minor Mineral.
No, it's
Concession
okay, as amended.
Yes,
Yes, as
in
amended.
2021.
As amended in 2021, it has been provided that in the event the contractor does not pay the requisite forest royalty, then the duty is cast on the employer
Chip is a central government undertaking.
as a central government undertaking.
Because the.
Okay,
The
it's okay.
language is, if Lordship permits me. The minor minerals when shall be used or consumed by central government departments or any of their agencies. The rates of royalties shall be as per the rates prescribed in the third schedule, appended to these rules, and such
No, it's okay.
department shall
It's
ensure
okay.
that prescribed thing is. recovered.
It's okay. To the central government agencies, the duty is cast on the central government agencies to ensure that the requisite forest royalty is either paid or be deducted and remitted by the
By the contractor, it's paid by the contractor.
paid by the contractor, paid by the
Or
contractor,
deduct, we
or
deduct from
be deducted from the payment due and remitted to the
department.
forest department. So accordingly, it is submitted that the opposite parties number 4 to 9 would otherwise have no objection to process the payment, the bills of the petitioners, applicants.
Rather than recording it as my submission, my lord, will your lordship give the
Okay,
liberty?
okay.
That-
Full stop. When I said that his statement, and just put a full stop there, and accordingly submitted that the opposite parties number 4 to 9 would be bound by the directives of the state of Assam as provided in the aforesaid rules within bracket as amended, bracket closed. Next para. Taking note of the submissions of the learned counsel for the petitioner, applicant, and on hearing the learned counsel for the opposite parties number 4 to 9, the court is inclined to provide that in the event the applicant is unable to satisfy the opposite parties number 4 to 9 about payment of royalty, if there is no other impediment, the said opposite parties shall process the bills of the petitioner by retaining the forest royalties and other dues payable, as per law, be permitted to release the contractual dues of the applicant. Next para. The the applicant shall produce a certified copy of this order before the concerned opposite parties to bring the order to the notice of the said authorities with a copy thereof to the learned counsel for the said opposite parties. This interlocutory application stands disposed of.
Difficulty is not in the petition, the order which has been passed
Yes, ma'am.
by relying on the OM, my lord, that OM is no longer applicable. That is the difficult. There it says that you have to produce the originals. That is why the NRL authorities are insisting for the originals.
Oh, acha, acha.
But now the system is, my lord, previously what used
Then
to
can I
happen is-
record that part?
No,
No, not record. Okay.
Previously, what used to happen, my lord, whatever sand, gravel is being used, my lord, on the quantity forest royalty is to be paid.
Yes.
Now the government has come up with an amendment says that no, irrespective of everything, project cost 2% for RCC.
But my lord, in the 5-1, my lord, for the other.
I am, this bench is partly responsible for that.
Because, my lord, I think this honorable court has held that if there is no agreement between the parties for deduction of
No,
forest royalty,
the question is that you see that there is a practical problem. It happened about 1.5, 2 years back. Taking up the bench. A question arose and then I am already, what you call, notorious for giving bad examples or horrible examples. I said that when we are traveling at the night hours and in the early morning, entering into Guwahati or going out of Guwahati, you see hundreds and thousands of trucks standing on the road. If we come by flight before landing Borjar, we find in the right side the hillocks. Absolutely, it has become a plain ground. So, a lot of deliberations took place, and thereafter, after about a year, this came out. The officers were called here. We had deliberated what is being done. There's another reason. The reason is that if in any evening you come and stay with us in the official bungalow, you will come to know that every night only it is dumpers who are traveling. And these people, they are what you call, they will not know the time, and they will just, even in the dead of the night, when there is no one, they will honk their horns. At times it creates.
in fact, Manoj, there are a lot of litigations we are facing because of this forest royalty clearance. Then arbitrations are going on. There they dispute the quantity of stone and gravel used. It leads to a lot of complications. Now it is clear now. It is as per in my opinion, Manoj, not the opinion of the party, Manoj. In my opinion, this is better.
Well, it comes from the quantum.
Yes, on the bottom. You
So
get a job
whatever-
of 1 crore, you pay 2%, end of the matter.
End of the matter.
End of the. It's much easier now, at least
Much easier.
At least to recover the royalty.
Okay.
Oblige.
So, wish you all Happy New Year in advance to all of you present. Huh? Oh, this W in the repetition, what order is to be passed? There's an order in the repetition.
We have filed our affidavit.
My lord, I will
So-
send one reply, madam.
You'll find a reply, okay. In the connected writ petition, you write, same heard, now he'll be petitioner, Mr. Sharma will be petitioner. And Mr. Deka will be for respondent numbers 4 to 9. Same thing. Now he will be petitioner, not applicant, and he'll be respondent numbers 4 to 9. Same thing, none appears for call for other respondents. And say that on the prayer made by learned counsel for the petitioner, matters are adjourned to enable him to file affidavit in reply. Full stop. List after 4 weeks. End of the day. Yes.
Item 43.
43, yes. Any other matter? No.
Hearing of the 24.
We adjourn. Yes, Mr. Udin.
Page 21 is the subject question of law, I can remember.
Just a moment. You are the plaintiff or the defendant?
I'm the plaintiff.
The suit and the appeal both were dismissed.
No, but
suit is partly decreed.
But and same was achieved by the
Where is the plaint?
Page 87.
87. But you won't get anything. There will be no substantial question of law. You see, you see, you're asking for right title and interest in respect of B1 and C.
B1 and C.
B1 and C. Now, how do you claim the ownership of this B1 and C is by virtue of registered sale deed? The registered sale deeds are exhibit 2 to 5,
Yes.
correct? Now, all these exhibit number 2 to 5 are certified copies.
So this, both the, trial court as well as the appellate court has not questioned this matter. And there
No,
is
no, you see, if the document is per se not admissible, even in second appeal, we can't give it seal for approval of that having been proved. Because you see from the judgment, when these issues are decided, the question of the court has not narrated. At least I did not find. You see, when I'm reading alone, I don't read so thoroughly. But prima facie, I did not find any explanation about section 65 that you have introduced to before the court that the original could not be produced. That permission of the trial court is not reflected in this judgment.
No, madam, the person who signed and they are examined, madam, PW, SPW 4 and 5 actually, madam. And these were also exhibited, madam. And according to the recent Supreme Court judgment also, madam, the certified copy is admissible.
It is not. Section 76. It is not. You see, the reason is very simple, that the court will have to, the provisions of 61, 63 has to be complied with, and 62. This 3 has to be complied with. And therefore, an explanation has to be tendered why original could not be produced. You see, we can't say that certified copy is not admissible. It is admissible. But it has to be preceded with an explanation of why original could not be produced. Otherwise, you see, what is the meaning of section 61, 62, 63? Because 63 says evidence should be primary.
So in my, judgment also reflected, we have explained it, it is in the office manner and it will be called. Then the explanation manner.
No, no, no. No, no, you see, you have the CPC with you.
Yes.
You see, order 18 rule 4, then come to proviso. Order 18 rule 4. Then come to proviso. Provided that.
Provided. Any other party shall be entitled to tender as evidence and rely upon any admission made in such an act.
No, no, proviso.
Recording of evidence.
Recording of evidence. 4. Then come to proviso.
Court may well appoint.
No, no.
I think
You're reading something else. You're reading order 18. You're reading rule 4. No, no. Then you're reading something else. Order 18 is provided the documents are filed by and the parties rely on the documents. The proof and admissibility of such documents which are filed along with the affidavit shall be subject to orders of the court. Correct. You got it? No. No, it can't be. There can't be mistake in the book. You may not know how to read. Just give it that book. Not comments, comments over. 18 is there.
The documents are filed, and the parties rely upon the documents, the proof and advancement of such documents which are filed, along with the affidavit shall be subject to order of the court. Well, in this regard, my lord, page 57 of the judgment of the my lord, trial court.
Yes.
It is in written, my lord. In last part, my lord. The registered sale deed file number so and so, sale deed number so and so, so and so, and registered sale deed number so and so executed at sub-register office, Colgasia, are being kept in the custody of the concerned sub-register office, and hence the plaintiff failed to produce the said deeds along with the plaintiff before the court, and prayed for liberty to produce those deeds, sending the production notice to the concerned sub-register office as per provision of law. The promoted defendant are.
No, this won't take us anywhere. You see, if the document is with the registrar, then the registration receipt will be with you. You see, you are leading evidence when? In the year 2013,
Certainly.
correct? It's a sale date of 2010. Why they would not return it by then? There must be some explanation. If you say that it is with the sub-registrar office, where is the registration receipt?
The finding which was not given. in my-
No. It doesn't take us anywhere, Mr. Uddin. Because you see, how you prove a sale deed? By proving the signature. In a certified copy, how do you prove the signature? You have to call for the original and then claim right title and interest. If there's a certified copy, whether somebody admits or not, it still remains inadmissible. Take it after reopening, because
I'm satisfied, my lord. Some-
with this, it leads to
PWD
dismissal
4
of your.
and 5, PWD 4 and 5. Yes. Original photo.
No, it will lead to dismissal, Mr. Uddin. You better take it up after that. Because if I enter into it, then I'll be dismissing it.
But my lord, what the court, my lord, finding that the registered sale deed is admissible.
You see, nobody says it is inadmissible, but still we can refuse to take that. You see, I'll tell you why. You have this evidence act, give it to him. No, because this is something which I am thoroughly aware. You take this. You see 165. Last section. Second proviso. Provided that.
The judgment must be based upon the facts declared by this act to be relevant and newly proved. Provided also that this section shall not authorize any judge to compel any witnesses to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive, if the questions were asked or the documents were called for by the adverse party, nor shall the judge ask any question which it would be improper for any other person to ask under section 148 or 149, nor shall be dispensed with primary evidence of any document. except
Correct.
if it-
Nor he shall do it. So the action of the court to dispense with the primary evidence itself goes to the root of the matter. You got it now? So if the trial judge does not have that authority, that circumstance is the power of the court. 165 is power of the judge. So that power of the judge is taken away. The primary evidence can't be dispensed with. That's why I said it will not take us anywhere. Correct? Because this is subject which I am acquainted. On the prayer made by Mr. Jiuddin, counsel for the appellant, matter since adjourned today. List after Mr. Second appeal. When?
Sir, 5 minutes.
After fifth. Okay. List on 8/1/2024.
That is what this question will not now arise. Otherwise, both the court may not
No, that's okay.
finding.
I'm not blaming you, but since I'm aware of this, I'm asking that question.
But, my lord, this is Supreme Court judgment.
You see that we have an answer to that. That's why I'm saying I'm pretty confident. You see, in none of the judgments, it says when the other side produces a certified copy and it's a matter of public record. Your own certified copy is not a public record. It's a private record in a public, what you call, in the hands of a registrar.
This question arises in FT court regarding.
That's why we say that, you see, that's something you'll have to call for the originals. Then prove it and send it back. If you have not proved the money receipt, the prima facie proof that it is lying with the registrar also goes. So then 165, primary evidence could not have been dispensed with.
All right.
I can.